Good afternoon, and welcome to the Florida Bar's Vision 2016 Commission's presentation on a transforming legal environment, setting a new course for success. Indeed, I'm excited about the program that we have today. As you know, many of you know, this is the one-year mark of our rollout of Vision 2016, which in its name implies a 3-year study at where our profession is going, but more importantly, after study, trying to find pathways how we can make adjustments within our practice as a whole, within our Florida Bar, and come up with tools to help navigate a new frontier. It's exciting that we're looking at the 4 areas of Vision 2016. Today, you're going to hear from some great authorities on subjects of change. One in particular that I want to introduce to you is a consultant of international claim. He's been so kind to be with us for the entire first year of this, and we're going to keep him engaged because he brings so much knowledge to our commission. But before we go there, because of the fact that we're talking about the future, we're talking about how we can connect with more people in a more effective way, it's really critical that we start using some new technology. And one of the things that I illustrate, I think, within my practice of trial law, it makes no sense to leave Fort Lauderdale and to travel to Miami in rush hour traffic for about an hour and a half for a 2-minute hearing, and then to get back in the car and bill that client 3 hours for something that took literally less than 5 minutes. We have different tools. So not only are we looking at how we can make adjustments, but we got to change culture. We have to change the culture of our own lives, of our judiciary, of our legal practices, so that we can be more efficient. And that's what I want to get out of Vision 2016 as we move forward. Because we are webcasting live, I understand there are over 1,000 people that are already plugged into this. And that's exciting. Those are people that could not make it here, but can still benefit from the dialogue that we're going to have, and not only benefit from it, have input in it. At the end, we'll be taking some questions of individuals around the world. And that's exciting. That is cutting edge, and I'm really looking forward to that. I want to make sure that anyone in the audience or viewing the webcast can make comments about the showcase and read the comments and observations of others through Twitter by typing in hashtag FLABAR Vision, VISION. That's FLA, F-L-A, bar, B-A-R, Vision, V-I-S-I-O-N, 2016. Hashtag FLA Bar Vision 2016. At the end of the program, there will be an opportunity for those viewing the webcast to also submit questions to the panelists that we will be hearing from. So with no further ado, I want to introduce Mr. Jordan Furlong. Jordan Furlong is a lawyer, a consultant, a legal industry analyst who forecasts the impact of the changing legal market on lawyers, clients, and legal organizations. He has delivered dozens of addresses to law firms, state bars, state law societies, law schools, judges, and many others throughout the United States and Canada on the evolution of the legal services market. He is a principal with global consulting firm Edge International and a fellow of the College of Law Practice Management. Mr. Furlong is the author of Evolutionary Road, a strategic guide to your law firm's future, attorney at work, and author of the Content Marketing and Publishing Strategies for Law Firms, published by the ARC Group. He also serves as a legal innovation strategist in residence at Suffolk University Law School in Boston, and is the co-chair of the board of Suffolk's Institutes for Law Practice, Technology, and Innovation. Mr. Furlong lives in Ottawa, Canada, and writes at Law 21, named 6 straight years by the American Bar Association Journal as one of North America's top 100 legal blogs. I welcome to the stage, and I'm excited to hear the presentation of Mr. Furlong. Mr. Furlong.
Awesome. Thank you very much, Gene, and good afternoon, everybody. thank you very much for coming today. Thank you for the opportunity to be here with you. And yes, as advertised, I am Canadian, a Canadian in Florida. Who would have thunk it? You know, it's not like we ever show up here or anything. I'm delighted for the opportunity to be with you today to talk about the just extraordinary changes taking place right now in the legal marketplace. That is the Chicxulub crater. Or, well, that's an artist's rendition, I guess. We, of course, can't really see it anymore. It's buried at the moment under millions of tons of rock and water and earth and so forth. But if you'd have been around, say, 65 million years ago, in the vicinity of the Yucatan Peninsula in Mexico, and I guess if you had access to some kind of airborne suborbital photography equipment, then you could take this picture as well. And I think it's fairly impressive, and I think rather magnificent. So why is it here? It's here because I think that the Chicxulub crater has something that it can tell us today. About more, by the way, than just the extinction of the dinosaurs, right? Because for most of us who are familiar with this is how we know of it, right? This is the impact crater of the asteroid or the comet or whatever it was that slammed into the Earth 65 million years ago and killed all the dinosaurs, or so the story goes. And that is part of why it's here. But I think it also has something to tell us today about climate change, and a climate change on a far more severe and vast scale than anything we're all talking about today. And I think it has something to say to us, honestly, as lawyers. Partly because we will occasionally hear people talking about, oh, there's a mass extinction event of the legal profession coming. Something, by the way, you're not going to hear from me today. But also because as lawyers, as practitioners, and as members of our profession, we are also in a situation where we're dealing with climate change of our own. We're dealing with serious change, unprecedented change in the environment, the landscape of legal services, in the purchase and sale of legal services. And I do think that there is great value in being able for us to go and look into the distant past to think about how to cope with the very near future. Dinosaurs are awesome, aren't they? Seriously, I mean, I've got a couple of small kids at home, and so I've gone through pretty much every dinosaur book there is. It's odd to me in a way that we actually treat the term in a kind of a negative fashion, right? You know, how often do we say of someone who is, a barrier to progress, or someone who won't, listen to reason, that old dinosaur, It's like, dinosaurs, they ran the world for like 200 million years, right? We've been around for what, 10,000 maximum? So I personally think we should be a little more careful about, who we're calling dinosaurs. But they're amazing creatures, and again, lovely artist's rendition. Had we been around 65 million years ago, perhaps this is the scene we would have seen. But I actually think if we had been on the ground at that time, what we would be more likely to have seen is this. Because the Earth, at the end of the Cretaceous period, was just being convulsed with volcanic eruptions and activity almost beyond any scale we can cope with today. As an example, there was this massive supervolcano field in the size and location of modern-day India, okay? And it was erupting for almost something like 20,000 consecutive years, right? So get our heads around that. What kind of, if you had been on the ground at that time, again, this would be most likely the scene outside your living room window, right? The air would have been smoky and filled with particulate matter, difficult to breathe. The sun would have been very dimmed. It just would have been a fairly unpleasant, nasty atmosphere. And this was going on for year after year after year. And it was very hard for plants and for animal life, but you struggle along, you do the best you can. And it's into that environment that, bam, here comes eventually. It's gonna come, I know it. Wow, this was going so well. There we go, beautiful, look at that. Here it comes, the magnificent Chicxulub asteroid. Although actually, I don't think it looked anything like that. It was like 40 square miles tops, okay? But it's such an awesome picture, I had to use it. So here comes the asteroid, right? Smashes into the Earth, throws up millions upon millions of tons of vaporized earth and stone and water and limestone, throws it up into the air, and it finishes the job that the volcanoes have started. The air is completely enveloped in smoke and ash. The sun is simply blocked out certainly for years, right? Quite possibly for longer than that. And the damage that was done to the Earth was, of course, beyond imagining, right? Photosynthesis stops altogether in the absence of the sun. Plant life dies off at a staggering rate. And it doesn't take long after that before plant-eating dinosaurs, deprived of their food, they start to die off. The carnivorous dinosaurs, deprived of their part of the food chain, they die off. And in what is, for us, the equivalent, in geological terms, the blink of an eye, this species that for 200 million years, ran this planet, right? Gone. Just like that. Now, I'm not here to draw comparisons between lawyers and dinosaurs because, again, I think that's an insult to both groups. What I am here to suggest to you today is this, that if you were in a law firm of any kind, whether that is a sole practice or a small association or partnership with a few colleagues, or you're in a mid-sized, large firm, national, global, doesn't matter. If you're in a law firm today, then you're operating within a business model which evolved in a very different time, a very different climate than what we have today. And the difficulty the difficulty that the dinosaurs ran into is the same difficulty we have today. The dinosaurs existed for 200 million years. How did they do this? Because they were masters at adaptation. They evolved perfectly to fit the environment of their time. But when that environment changed, very suddenly, very severely, they couldn't adapt fast enough. And that is a problem we have today. Our law firms, our business models, our whole conception and infrastructure of how a law firm should operate evolved in a time that was very different from what we have today. Your law firm, I will go so far as to say it almost doesn't matter when it was founded. If you trace your roots back to the 20s, 1920s, to the 50s, the 70s, the 80s, whatever, almost choose your time. Your law firm evolved at a period in time when lawyers had completely unfettered and unopposed access to the legal marketplace, a de facto and de jure monopoly on the provision of legal services. At a time when clients had almost no knowledge about the law, very little sophistication, and even less power or ability to affect the way in which their lawyers operated or how they dealt with their lawyers. And it evolved at a time when the most challenging type of technology to cross anybody's desk was quite likely the IBM Selectric typewriter, which I shouldn't diss because it was a great typewriter. But we now live in an environment which is utterly different. And if your law firm or the law firms of your friends or your colleagues are struggling, and many are, to keep up with with the nature of the market, I submit to you, it is because it developed in a different environment than we have today, a completely different climate. You know, I'm going to have to walk over and probably switch. There we go. Or maybe switch one of these things at some point. But this is my point, right? The dinosaurs were a dominant species because they evolved to fit their environment. That's how they adapted. But suddenly, catastrophic change comes along and mass extinction. That is what we're up against. Not as lawyers, right? I have a very strong belief that there is a place today for lawyers, and I believe there always will be. But our business enterprises, our vehicles, the methods by which we deliver legal services to our clients, those models now are in a lot of trouble. And we need to find ways to help them adapt and move forward. And that really is what I want to talk with you about today. I want to discuss with you the sense of how much is changed in the legal market, the climate and the environment of the purchase and sale of legal services. I want to talk a little bit about the forces that have gotten us to this point. And I want to suggest to you a series of recommendations for how we can get past this, how we can make our own adaptations and start to become a very different profession than we were before. That is essentially what I'm hoping we can chat about this afternoon. in order, I think, to really get a sense of what our challenges are and how we're going to be able to cope with them, I think what we need to do is have an understanding of exactly what we're up against. You can't know where you're going to go until you have a sense of where you are right now, obviously. So in order to do that, I want to switch metaphors slightly. I want to move us away from the Mesozoic era to today. I want to move us out of the Gulf of Mexico, bring us over to the Atlantic side of the state. And I want to suggest to you that first of all, we need to get a sense of what is the nature of the storm that we're currently dealing with right now. What does it look like? What does it feel like? What are we all going through? I have the opportunity to speak to lawyers in any number of jurisdictions in many countries. And from that comes the chance to really collect information about what lawyers in firms of all sizes are coping with. What I find on a very regular basis, sorry, I'm going to have to pause for a moment just to switch because we're having a few difficulties with the machine here. If you're on the podcast, if you're watching on the webcast, you check your Facebook account, go into Twitter, follow the stream. See if that one works. Yes, there we go. All right. Grab a drink if you're having a drink of water. If it's stronger, that's fine too. No one's going to say anything. And we're back. What are we up against? Obviously, the economic downturn, it virtually goes without saying at this point. Certainly the triggering event was most recently was the financial crisis of 2007 and the painful recession and the only slightly less painful recovery we've had since then. And I do know that, especially here in Florida, there's been particular factors that have made it even tougher as well. It's hard on us. It's really hard too on our clients, on the purchasers of legal services. They don't have the money to spend on legal services they had in the past. Or if they have money, they are diverting it to other sources. And this applies to consumers, to individuals, to families, small businesses, corporations, institutional buyers. Choose your client base, pretty much right across the board. And it's no surprise then that many law firms are struggling with a decline in revenue. And again, this is across the board. If your firm is not, if your firm is seeing a continued acceleration in annual profits, or at the very least has had only a small level of growth, that's fabulous, and congratulations, that's great stuff, and I want to hear from you afterwards because we'd like to know how you're doing it. But the vast majority of lawyers are finding that business is off, revenue is down. Survey just like literally this morning, I'm reading today, latest release from a company called Time Metrics, which studies that the legal spend of corporations of various kinds. And they're reporting that for law firms outside of the really big ones, the AmLaw 200, in the first quarter of 2014, revenue was down 9% year over year from last year. And it wasn't that hot this time last year either. So we're up against that particular rock as well. But it's not only that, our clients are pushing us harder as well. Clients are becoming much more formidable as an organization, as an entity, right? They are pushing us, they're pushing us on the things that we're used to in a way, right? They send an email, and then 10 seconds later they're waiting, why haven't you answered me yet? That kind of thing. But at the same time, they're also pushing us in other directions. They're pushing hard on price and on fees. I want a discount in your hourly rate. I want to pay less for this whole thing. I want you to start giving me a fixed fee or a range of fees. Give me some certainty. Give me some predictability in the rates that you're charging me. This whole thing of when I ask you how much is it going to cost and you say, well, I'm not sure, or it depends, they're not buying it, and they're pushing back really hard on that. So we have that to cope with, plus we are dealing with much tougher competition than we have in the past. And some of it coming from within the legal profession, because various firms and various lawyers are starting to adopt very kind of innovative and assertive new business practices and approaches that are starting to carve into our own markets and our own territories and our own client groups. But a lot of it's coming from outside the profession. The quote-unquote non-lawyers. We'll come back to that later on. And this is sweeping in. This is flooding into the marketplace right now. And this is the nature of the storm. Any one of these particular developments on their own would have been a challenge for us, but we got to cope with all of them at the same time. I came across a quote in an article in the Miami Herald this time last year. And I thought, you know what, this actually sums up quite nicely, and from a local point of view, exactly what we're coping with. Tim, if I could get you to pop to the next slide, that'd be great. I'll let you read that. And I think that's a reality for a lot of people right now. Now, when we talk about the legal market, we've been throwing that term around a fair bit this morning. I want to take a little bit of time to drill it down into a little bit deeper. Because I think part of the way forward, part of our ability to get out of this particular challenging area we are right now and into something better is going to be based on a better understanding of what the legal market actually is, what it looks like and how it operates. So, again, to borrow another maritime metaphor, I want to suggest to you that we're thinking about an iceberg here. Because as you will know, icebergs, as a general rule, not as a general rule, as a law of physics, icebergs, approximately the top 15% of the iceberg, that's the part above water, that's the part we can see. That's the shiny and then the sunshine part of the berg. We all, ooh, it's lovely, it's beautiful, that's great. But of course, about 85% of it is under the water. What I want to suggest to you, and what I want to go on to demonstrate, I believe, is that the entire legal market, in truth, can be compared to that entire iceberg. The 15% above water that we can see and we're familiar with, that's the legal market that we all deal with as lawyers. That's where we are today. That's where our clients are, the ones who are giving us money and paying us for the work that we're doing, right? It is paid, it's visible, it's concrete, and it's the transactions that take place every day, and that's great. And I think it's a very important point we need to understand about this 15%. When we talk about access to justice, okay, and we talk about this a lot, and we'll be hearing about it again a little bit later on today, and access to legal services. A very important point we need to understand. If you are a client, okay, and you're in the top 15% there, you do not have an access to justice problem. If you have the money and the inclination to hire a lawyer, you can find one. I have yet to meet a client who said, I got lots of money and I would love to hire a lawyer, but gosh darn it, just can't find one, right? It doesn't come up that often, okay? So we need to understand that when we talk about access in issues like that, what we're really talking about is the rest of the iceberg. Because down there under the water, where I can assure you it's very cold and it's very dark, okay, that's where huge numbers of opportunities, huge numbers of challenges and problems are existing, and that's where lawyers don't go, okay? That 85%, and the reason I say 85 is because in study after study, both statistical and anecdotal evidence, when we talk about the complete range of opportunities and people and businesses that cannot or do not access lawyers to help solve their problems, it consistently comes out in that range. Here's some stats. Check out these are all from studies. Check it out. I mean, sometimes it's in the 70s, occasionally it's in the 90s, but it's amazing how often that percentage, that number comes up again and again. And I think it's because that is a fair representation of the unserved, untapped legal market, needs that actually exist. I'm going to give you an example. I'm going to drill down into one of those examples, one of those stats. I'm going to use it from my home country of Canada, and the third bullet point there. Several years ago, back in 2007, actually, which is before the financial crisis, back when things were relatively rosy, right? Federal Department of Justice in Canada did a survey. Thousands and thousands of people, well within the statistical significance range, in case you're wondering, the sample size is completely valid, did this huge survey, and they asked people two questions. First thing they said, in the last 3 years, have you encountered what they defined as a justiciable issue? Which is defined pretty much as you would think it is, right? It's a problem or an opportunity or a challenge or an issue which is related to the law in some way, right? And which calls out for some kind of attention or dealing with something like that, okay? And the second question they asked was, and if in fact you have had one of these issues, what did you do about it? Check out the results of this survey. We are the least popular option for dealing with justiciable issues. And it isn't even especially close. Nearly half of all people who were surveyed said, I dealt with it myself as best I could. And if we want to know what those folks look like, we go to courtrooms and we find the pro se and the self-represented, or the people who print off documents on the web and fill them in, like a will or a divorce decree or something like that. They're mucking through, they are doing jury-rigged solutions, they're doing the best they can. Okay? A little over a third did nothing at all, just ignored it. And what's interesting, they actually drilled down into that one a little bit further too. They said, okay, why did you do nothing? It's an issue. Why didn't you do something? About 30%, give or take, but 30% said, because I figured the consequences weren't severe enough, or the problem wasn't serious enough that it wasn't worth dealing with. Okay, fair enough, good answer. But the rest said, no, it was serious. It was a problem. I just didn't do anything about it. About another little over a fifth got help, but it was not from a lawyer. They got help, they got some way or all the way towards a solution to their problem, but it wasn't from us. If you're interested, the top 3 sources of help that they went to, the first was unions, second was government, and third was family and friends. Now, maybe the unions part is specifically the Canadian context, I don't know. You will find different answers in different jurisdictions. What's interesting, by the way, on the previous slide, you saw a reference to a survey in England where of small businesses asked the same question, and what they found was 16% availed themselves of lawyers, 84% did not. And when they asked about alternatives over there, one of the top responses was accountants. And I think part of the reason for that is that recent legislative changes in Great Britain have allowed accounting firms, amongst other people and individuals who aren't lawyers, accounting firms can now practice law. Three of the big 4 accounting firms have legal service divisions and outlets. Ernst & Young Legal. Let's wrap our heads around that for a second, eh? Okay? And fewer than 12% came to us. I gave a talk the other day where I referred to the idea of the incidental lawyer. How lawyers are in great danger of becoming incidental to the legal market, of becoming peripheral. And this goes against our instincts. Our instincts are to say, but we're integral. We are absolutely necessary. But the statistics aren't really bearing us out on that. What I find, to my mind, I think, if we are in a position where we have a better sense of what the whole market actually looks like, right? Then I think we can be in a position where we can start thinking about what solutions can be crafted. Because this is the situation we're up against right now. For the 15%, the people we actually deal with, the clients who retain us, as I mentioned earlier, they're pushing us hard. They're looking for new options. They're looking for new ways of dealing with us in some way. They still want to deal with us for the time being, but they are not satisfied with things being the way they've always been in the past. Okay. But the 85% aren't even paying attention to us. And the reason for that, by the way, is that we don't pay attention to them, right? And that's not a criticism, right? That's just a description. Lawyers do not have an interest in serving clients who have issues or problems or opportunities, the value of which is not high enough in monetary terms to justify the investment of our time and resources, right? If it's not profitable work, we're not going to take it on. And that's fine as far as it goes. We made the choice to serve the 15%, and that's fine, okay? But the 85% now say we want other options, and the thing of it is they're getting them. What's happening now, and this is something that has not happened before, in the last couple of years especially it has accelerated. What we're looking at is the emergence of a support network for self-representation. We're looking at the process of normalizing self-representation, self-navigation through the legal system. I'm going to talk shortly about legal technology and startups, which is a big part of this, but even in the more traditional parts of the profession, of the legal community, courthouses increasingly are setting up, they have staff on hand to guide people through issues, or kiosks where you can get resources and materials to assist you. Lawyers increasingly are setting up what are called limited scope retainers, sometimes called unbundling. And some of you may be involved with this, right? And the idea there is that you say to the client, look, I can't do everything for you on this case, but I can do some things, right? I can draft your materials, I can ghostwrite your motion, or something like that. I can coach you from the sidelines when you go out in front of the judge and what to say and where to stand and so forth. But I'm on the sidelines, you're on the playing field. We're getting close to an extraordinary and I think potentially very chilling event. When you look at numbers, when you look at these 85% numbers, when you look at the growing numbers of self-representation and so forth, we're coming up to a point where something we have long assumed to be the case will no longer be the case. We have a built-in assumption as lawyers that the default setting, the normal way of doing things in the legal system is that if you interact with the legal system in any way, you have a lawyer with you. If you go to court, you go with a lawyer. If you're going to get a will done, you go to a lawyer, right? This is such a basic assumption for those of us in the legal system itself. We don't even think about it, right? It's like water for fish. Fish don't know what water is, right? Same kind of idea here. And we view the notion of self-representation as an aberration. It's abnormal. One of the best examples I can give you of this, I gave a presentation in Seattle a few months back, and in preparation for that, I did some research into in Washington State, which in other respects is actually very advanced in this area. Washington State pulled together some materials to help guide you, supposedly, through the legal system. So you download the document which they give you to navigate your way through. And first paragraph, okay, and there's a lot of paragraphs. First paragraph, middle of the paragraph, all caps, which as you know is shouting at people, okay? And it essentially says, if you engage with the legal system then by yourself, then you will be assumed or deemed to have the same information and qualifications as a lawyer. You will be held to the same standards, right? And I said, you know what, you could save yourself a lot of paper just by saying, don't come here. We don't want you here. And we don't. Our legal system is not set up for people to do this by themselves. And yet, this is where we're going. This is what's emerging. Okay. What does this mean in practical terms for us? What's coming our way? What's the nature of the wave that is being produced by this storm? I mentioned legal technology a moment ago and legal startups. I want to throw another stat at you that came out several months back, which really got my attention when it came out in terms of the money that's being invested right now in startups for the legal field of all kinds, technology and otherwise. $458 million last year. In 1 year, in one country, in fairness, the largest market by far in the world for legal services, but still, nearly $500 million poured into legal startups, technology-based companies, or software, or new processes, new systems that are designed to do things differently in the law. I think if you took the top 1,000 law firms in the United States and asked how much did you spend last year on R&D and totaled it, I don't think you'd come within miles of that. Right? Now, approximately, again, 30, maybe 35% of that money is being poured into entities and businesses and software that is geared towards law firms and lawyers, to help lawyers and law firms practice more efficiently, be more productive, and so forth. Which is great if you have a practice whereby being more efficient will actually help you be more profitable. But of course, the problem for most law firms is that that's not the case, right? In most law firms, the more efficient you are, the fewer hours you spend doing something. And because the billable hour is our inventory, we're actually shrinking our stock and trade. So why would you do that? Okay, fine. But the bulk of the money is going into startups. It's going into companies. 200 million of that went into LegalZoom. How many folks here know about LegalZoom? Right? 200 million bucks in outside investment. They generated about $147 million in revenue last year, right? And that's one company doing one type of thing. A very interesting company, by the way, but you know, that's fine. That's one crest on the wave of what's coming our way. What we are experiencing now, what we can continue to expect to experience, is a whole bunch of different things. First one, with apologies to Messrs. Cameron and Schwarzenegger. Actually, no apologies, I don't like those guys. But the rise of the machine, right? In terms of what technology is able to do. I give entire presentations just on the developments in legal technology. And I will say this, I am not among the people who fully subscribe to the idea that technology is this unstoppable juggernaut that's going to transform the world and the singularity is near and so on and so forth. I don't personally buy that, mostly because I have to reboot my computer at least once a day, so I'm not really convinced that we're that close. But even for all that, the advances we've seen in the last few years, to even just scratch the surface, there's software on the market right now that will create airtight, commercial-grade, enforceable contracts in a matter of minutes for a few $100, that will conduct due diligence of existing contracts for the purposes of mergers and acquisitions and similar deals. There's what's called expert applications, which are systems that derive knowledge from lawyers and from the knowledge management of law firms and end up in a system whereby, as a person who is not a lawyer, you sit in front of the system, you feed it in questions, and it will answer legal, regulatory, compliance questions, again in a matter of minutes, without the use of a lawyer. In litigation, something called machine learning, often sometimes called predictive coding. It is changing everything we assume about the process of deciding what documents are relevant for the purposes of litigation. These are machines that will absorb the results of lawyers going through deciding this is relevant, this is not, this is relevant, this is not. And after a short while, the machine gets the hang of it and starts doing it faster and then faster again. And eventually, with this huge amount of documentation, it's like a wood chipper ripping through it. Way faster than human lawyers can do, far cheaper, and what is most remarkable about it is that they do it better. The success rates for these predictive coding operations consistently come out ahead of what especially mid-sized and large law firms are able to manage with their associates, right? So this is what's here now. This isn't coming down the pipe. This isn't in development. This is here today. Non-lawyer competition. I have to take 60 seconds just to do a little rant. The whole term non-lawyer, it's part of my appeal. Can we please stop using this term? Because it's this thing we do as lawyers. I don't know why we do it, but we divide the world into us and not us. And nobody else does this. I have never heard of anybody talk about non-plumbers. It never comes up. Right? Non-nurses, is that a term you hear thrown around in the healthcare industry? Right? But we do this thing. And when we talk to people who aren't lawyers, who work at law firms, and you say, do you like being called a non-lawyer? They say, no. Because people don't like being described as the absence of something else. So anyway, end of rant. But it's a term of art, we'll use it here. Competition from non-lawyers. It's here already. It's going to increase. It's not turning back. We can have all the unauthorized practice of law, regulations, and statutes on the books that we like. We're not turning it back. Going back to our friends at LegalZoom. About a couple of months ago, there was a settlement in South Carolina in a litigation between LegalZoom and a lawyer there who had brought a suit against them. And as part of the terms of settlement, a judge of the Supreme Court of South Carolina ruled and stated that LegalZoom is not engaged in the unauthorized practice of law. Now, with great respect to LegalZoom, but if that's not the unauthorized practice of law, what is? Right? Now, LegalZoom is doing a lot of very smart things, and they are partnering with the lawyers and setting up relationships with individual sole practitioners and small firms, and that's great. But I said several years ago, 4 years ago, I wrote that I think UPL, as an effective tool in lawyers' arsenal, has less than 10 years to go. And I think that's probably right. But it's not just non-lawyer providers coming into our marketplace. It is legal service entities run by non-lawyers. In Australia for the last 10 years. In England for the last 3 years, regulations have allowed law firms to be floated on the stock market for shares to be sold, to be owned by hedge funds, to be owned by supermarkets, conveyancing companies. Very briefly, there was a trucking company. That actually died, and a good thing too, probably. But this is, and this is not here in the US yet, but I am willing to wager it really is only a matter of time. It's going to be only a matter of time. Do-it-yourself DIY law, right? Because it's a DIY world. And if we have any doubts about that, we just have to find a travel agent and ask them, if you still can. And I think what it's all encapsulating is the decline of the traditional law practice. Notice I do not say the decline of the lawyer. Notice I do not say the extinction of the lawyer, but the decline of the traditional law practice, the law firm, the one that evolved in a very different environment, in a bright sunny field called the 20th century, where the breeze was lovely and the sun was shining, right? And that's not today. And I don't think it's going to be this way for a while yet. So that's the challenge we have up against us. So how do we get out of this? And how do we find a way forward? How do we navigate through this storm? With a very huge caveat that I certainly am not here to say, it's this way, come, do all these things, you're going to be fine. What I have for you are some suggestions and some ideas. Your mileage may vary, as the saying goes. And there are any number of great solutions, great opportunities that I don't even have time to go into today. But I recommend, if you're interested, come up to me afterwards. I can point you to as many resources as you like. There's lots of tools. There's lots of roads forward. There's lots of ways forward. By no means is there only one solution. But I would like to touch in our time available on 3 points in particular that I think are essential. The very first one, know your cost, fix your price. There's this thing I like to do. I'll go into a law firm and I'll say, how much did it cost you last year to serve your clients? Right? Not to run your business, but to actually serve your clients. And they can usually find this out. It's on the tax return somewhere, right? So okay, that's great. How much did it cost you to serve your top 5 clients, to deliver the services and products to them that you sold last year? That takes a little longer to dig out, right? Most businesses and industries, I think, would probably have this closer to the fingertips, but law firms would have to kind of dig and find this. And then they will bring this forward and say, okay, our top 5 clients last year, this is the amount of money that we spent internally on various resources to deliver these services. I said, okay. But let's take, for instance, this hypothetical client brought in $1 million last year. Looks great. But if you spent $950,000 to serve that client, then you actually made a profit of $50,000, and I don't think they're one of your top 5 clients, right? And in fact, if on top of that, the originating partner on this file, thanks to your compensation system, took home $300,000 on that client, then in fact, the rest of the firm took $250,000 loss on one of your top 5 clients. Many law firms don't track costs of service close enough to understand where and in what respects they are profitable, right? Because the point is not revenue. The point is profitability and sustainable profitability over time through service. That's the idea. That's what we're aiming to do. So the first thing, we need to know our costs. We need to know what they are as specifically and nail them as much as we possibly can. Because a lot of law firms don't know this to the extent that we should. And then when you have a sense of what your spend is, you have to find ways to decouple it from price. Because, again, in most law firms, your spend and your price are inextricably linked through the billable hour, right? Because billable hour essentially is cost plus pricing, okay? This is the cost of the lawyer down here, and we throw in whatever percentage we want for a profit, and there's the price up there. Fine. But if the cost of your lawyer goes up, so does the price of your work. And if the cost of your work goes down, so does the price of the work. But the range in the middle, the profit stays the same, right? It's like, remember the Price is Right, the range game, the little red zone, you know? The same basic idea. One of the many reasons to dislike the billable hour is that it is one of the least profitable ways in which you can actually run a law firm. In addition to being, fairly unhappy in other respects. If you're in a position where you know what your costs are, and you could take advantage of the growing number of tools and technologies and processes available, which I'll get to in a second, to reduce those costs, to run a more streamlined practice, okay, that's great. But then you say the price is going to be on a different, it's not hooked in anymore. It is separate, it floats free. And it is focused on different factors. Again, I do whole presentations on pricing, but the three things that I have found, and those I've talked to in the area have found as well, that pricing is linked to and has to be based on, in no particular order, obviously your own cost of doing business, right? If it costs you $10,000 to run a law firm, I suggest you make $10,001 at least. It has a lot to do with the competition, right? What the market is, what I like to say, what the market is collecting. I have no interest in what the market is charging, right? I don't really care what the lawyer down the block says his or her hourly rate is, because I know he or she is not getting that hourly rate. If you can say it's $300 an hour, what actually goes into your bank account? What do you actually collect and realize on that, right? Harder to get, but that's fine. But you need to know at least what is being charged, and ideally what is actually being realized on this. And if you're interested in this kind of information, by the way, companies like Time Metrics are very useful because they get their billing data directly from clients themselves. And the third thing, of course, as we all know in practice, is that it is geared very heavily towards the situation of the client. What is the particular problem in front of the client? How urgent is it? What's the relative value of it? What's the nature of the relationship with the client? Is this a brand new client, or is this someone you've had for 10 or 15 years? A friend of mine in the consulting business says, I don't know why we do this as lawyers. We treat our best clients the worst. Right? If we're trying to land new business, we'll say, oh, we'll lower our rates. We'll give you a great break on this. We'll do this, this, and this, and this. And the regular clients who've been keeping us afloat for 10 years, they get the rack rate. He said, why don't we switch that? Anyway, so eliminating cost plus pricing is going to go a long way to getting us down the road to where we want to be. Where do we want to be? The ability to create fee structures that are reliable, predictable, have degrees of certainty. Fixed would be great, within a range would be fine, risk-based, etc. Why is this necessary? Why is it desirable? Fundamentally, set aside for a moment the whole question of what actually clients would like, fundamentally, it's because our market, which is getting flooded with all these new competitors and all these new providers, they're going to go to the client world and they're going to say, we will provide these products, these services, and this is the price. They're doing it right now. Right? Go to LegalZoom and you say, Will's $79, or whatever the amount it happens to be. And when the market comes to us as lawyers and says, how much is your price? I don't care about your rate. I don't care about your bill. What's your price? And if we continue to say, I'm not sure, I don't know, then we're going to be at a huge disadvantage, which I don't see how we're going to overcome. And there's so many resources out there on pricing, by the way. And again, if you're interested, I'll point you to them later on. There's books written on it. There's blogs that are dedicated to it. And it is, I once wrote a blog post. I came to regret the title afterwards. It's called How to Kill a Law Firm. I think it was actually taken seriously by some people. But one of the things I talked about is pretend for a moment that you are running a business which is trying to enter the legal market. You have identified that law firms are your primary competition. How do you take them down? How do you eliminate them? What is their vulnerability? And I think the prime vulnerability for us as lawyers is price. Not just the amount of what we charge, but the fact that it is almost entirely variable. So if that's our vulnerability, let's address that as best we can. Adopt new technology and new workflow. Gave a presentation last month to a litigation conference, and one litigator said, not to me, but to someone afterwards who said it to me, said, all this stuff you talk about, it doesn't worry me in the least, because I'm a trial lawyer, I'm a litigator, and no computer's gonna be able to break into this work that I do. And I mentioned earlier, I don't believe in the mass extinction of lawyers, but I'm open to the idea that individual cases, yes, I think it's possible. Because litigation, in fact, I think is one of the most vulnerable, okay? The question isn't, can a machine do what I'm doing? I think the question we should be asking is, am I doing something a machine could do? And if not a machine, a process, or an outsourced individual, or someone who has a specific quality, a specific ability, a skill, a trait that I can use to do something work. I go into so many law firms and I see partners doing work that associates ought to be doing. I see associates and lawyers and attorneys doing work that paralegals and secretaries should be doing. And if you go into a large enough firm and look for the secretaries and they're gone, right, because they've all been fired. So that's fine. Business improvement, business process reengineering, there's all sorts of labels for it. It essentially comes down to being able to say, we have a system here whereby we can get work done more efficiently, more effectively. We have processes in place. It could be as simple as a checklist, right? Or a decision tree, a flow chart. It could be as complex as full-scale legal project management if you're so inclined, right? And again, tons of resources available out there on that. We can adopt these things and adapt them into our practices. As a friend of mine in the legal tech business says, humans plus machines are better than humans alone, but machines are not there to replace humans. There's absolutely no point in that, right? So it's really, what I always say to law firms is you equip. You don't replace, you equip, and you train and you upscale and you upgrade. And my last point is about the untapped market, the 85% we talked about earlier. Now, the most conservative estimate I've seen for the value of the American legal services market is $260 billion annually. And that's the 15%. Now, I am not suggesting in any way that you just multiply that by 85 and boom, there's the rest of the iceberg. No, right? Because a lot of the work that is lower down on the iceberg is not going to be as rich and filled with money and so forth. That's fine. But again, to refer you back to that survey from Great Britain, they did a survey of small businesses, 9,000 of them, right? Businesses with between 1 and 50 employees. And what they worked out essentially was that every single year, 84 billion pounds of potential work that could be done by lawyers was not being given to lawyers. It was being done by people themselves, or given to accountants, given to other people, or just gone without, right? There is value underneath that iceberg. For current clients, I won't go into the whole biz dev aspect of it here, but if our own clients today are also untapped markets. And if you have a current client, best way to be able to access more of that market, walk a mile in their shoes, see the world through their front window, and get a sense of what are not just are their needs today, but what their needs could be tomorrow. What can you anticipate their needs? Is there a measure of risk avoidance or risk minimization that you can provide to them? Because I'm sure that there is, especially for small businesses and mid-sized enterprises and institutions. And as far as new clients go, I encourage so strongly lawyers to think seriously about the rest of the iceberg. Now, if you want, you can strap on the scuba gear and dive right down to the very, very bottom tip of the iceberg, okay? And absolutely, the people there are in great desperate need and have very few funds to work with. And absolutely, that's an important need and a strong professional service we can provide. And if you want to go there, please do, it's great. But you don't have to go all the way down. You could start by going just beneath the waterline. Because what if you could turn that 15% into 20, into 16, right? What's the top of that 85%? What's it worth annually if you could access it? If you could run your law firm in such a way whereby your costs are low enough and your systems are streamlined and your processes are accurate enough that you'll be able to say, I can reduce my prices and still turn a profit. Because the point is to turn a profit. Nobody's out there saying, or anybody who shouldn't be listened to, nobody's out there saying that lawyers should be doing all this work and not getting paid for it. I believe we should get paid for it. And we are needed to provide these services. But it's really only a matter of finding a way to do so in a sense, that in a way that is going to make sense from a market point of view and from a sustainable profitability point of view. All right. I have battered you with images of storms and volcanoes and waves and so forth, which is kind of hard to deal with. Least I can do is end the day on a more pleasant note and a more pleasant image. Because every storm comes to an end, right? And all the challenges we have right now, they will evolve, and new ones will come up, no question. And new opportunities will evolve as well. But I am convinced that there is an ongoing opportunity for lawyers. Law firms, absolutely. I think if the vehicle's not working anymore, if it's breaking down after 100,000 or 500,000 or 1 million miles, and I kind of think that it is, then let's trade it in and get something new, okay? But the drivers are still needed. We still need lawyers, right? Because there's lots of things that you can automate and you can outsource and you can algorithm to your heart's content, but there's still a whole bunch of things where you need a human lawyer, right? You need our judgment, you need our counsel, you need our courage, and we need our wisdom, right? And that's where the opportunities lie. That, I think, is the new oceans, the new and unexplored territory that still awaits us. And I wish you absolutely every success in accessing it, and I thank you very much for your time today. So at this point, I'm going to be asking the members of the panels, and we have quite a few, to come on up and join us at the front and pull up their seats. But while we're doing that, and as a segue opportunity, wanted to see any thoughts, questions? I mean, we'll have questions at the end, but if you're interested in exploring any of these thoughts, we got a couple of. Okay, we have one live microphone at the moment. The other one's up at the front. We would have time for one or possibly two questions or challenges, observations, thoughts. Bring back slingshots. Oh, I'm seeing a hand. Oh, can you come to the microphone, sir? So this one right here, because that way it gets picked up on the webcast as well.
What do you, to how much of the 85% wanting to help themselves do you attribute television shows like the Judge Judy and the People's Court, where people are over and over seeing an image of a false image of how things work in the courtroom and get the idea, I can just go in there and tell my story tell a better story, a more popular story than the next guy, the judge is going to find for me, and tell my opponent off.
Yeah, exactly.
What effect is that having on keeping 85% or on that 85% and having so many people wanting to do it themselves?
I do think it is a factor, I think. I mean, I would think that anybody who's watching these shows would also probably want to notice that at least half the people who come in these shows don't get what they want, right? They lose. You know, but it's the old saying, right? You never think you're going to be the one. We all think we're the lucky exception. I think it's part of it. I mean, I think in popular culture generally, we have so many lawyer shows and litigation type shows that it kind of normalizes the sense of, well, that's not that hard. I could do that myself. That's fairly straightforward. So I think that's maybe part of it. But I would also suggest that perhaps it's a cause, but I think it might also be a symptom. Right? Why is Judge Judy so popular? Or Judge, I have no idea if it's Judge Joe Brown and these ones are still on the go. I don't watch them. But you know, there's an appetite there. There's an interest there for some sense that, yeah, we can make our way through this. We can get there. I think that the fact that these shows exist and they're so successful speaks, I think, to a strong interest and an appetite among people for a system of dispute resolution, if you will, fundamentally, and a system of being heard that they want and they desire very strongly. And I think, by the way, that that's a very sensible thing that they should want, right? Because that's what we should be going for. I mean, part of the reason, I gave a presentation last year to a very large contingent of judges, chief judges and chief justices. And I was making the point to them that you're very, very close to going out of business. You can imagine I brought that one over. But I said, you're close to going out of business in the sense of your role as the arbiter of private legal disputes, right? Because you are, it's not just that you're unaffordable. It's not just that you're labyrinthine. You are irrelevant. The vast, vast, vast majority of people, including the vast majority of the 15%, they don't go to you. You're way too expensive. You're too long. You're too unpredictable. And it's not a satisfactory result. And any number of new alternatives are emerging really fast. If this is an area of interest to you, check out something called online dispute resolution, ODR, because this is in its early days. I got a feeling it's going to catch fire. I got a feeling it's going to start taking off, and we're going to see what you might almost call parallel court systems emerge. Parallel private court systems emerge for the resolution of these disputes in ways that are quicker and faster and more certain. Okay, so I'm going to do the neat trick of continuing to talk as I walk up the steps and do a few things. And I'll tell you a little Canadian story in the process to pass the time. One of my favorite little Canadian jokes. I give a presentation to an American audience, and afterwards the person in the audience who's American comes up and says, "That was a great presentation, but you have a very strong Canadian accent. I couldn't understand you." And I said, "I don't know what you're talking about." So there we are. So I'm going to get this off eventually. What we have in mind now is this. Jean mentioned earlier in the afternoon, at the start of the presentation, that the Florida Bar has commissioned Vision 2016, which is this process by which we can analyze the state of the market, identify the most pressing issues that are coming forward to us now, divide them into 4 segments in 4 areas, and start to address them. And bring some experts, bring practitioners and judges and other people who are well versed in this area, bring them forward and say, okay, let's start studying this area, let's start coming up with solutions and guideposts and roadmaps and so forth, and bring them forward and start saying, how can we, by the time we get to 2016, what can we present to the profession? What can we give to the Florida Bar to say, we've looked at this area, we've looked at these issues, and from the practitioner's point of view, this is what we need to think about. Well, we have 4 committees under Vision 2016. And these 4 committees are studying 4 separate areas. One is the whole question of bar admissions. A second one is about legal education. A third is devoted to access to legal services. And a fourth is looking at technology. And I think these are 4 absolutely essential points. I didn't have a chance to talk about law schools earlier, but believe me, I can talk about those all day too. So what we want to do right now is we're going to invite the chairs of these 4 committees to come on up, and we're just going to have a short conversation, and they're going to tell me and tell everybody here about what their committee is doing and what their issues are. So if we can start with Lance Scriven. Lance, if you could come up and join us. Oh, yes, sorry, grab the microphone too. Sorry, there we go, slides out nicely. I wasn't sure what, depending on what era, it's either Johnny Carson or Jay Leno or Jon Stewart, but whichever one works best for you, that's the vibe we're going for here. So, okay, Lance, thank you so much, obviously, for coming here. Can you start just by telling us a little bit about yourself, where you're working, and what you're up to these days?
Hi, I'm Lance Scriven. I am a commercial litigator in Tampa. Been admitted to the bar for 27 years, and I'm with the Trenum Chemical Law Firm.
Awesome. Now, your Bar Admissions Committee has a whole lot on its plate, obviously, because there's so many topics and issues that emerge from there. And you've got a list on the screen here of some of the primary ones. Let's just go through those as we have time to tackle them. Tell us a little bit about reciprocity in bar admissions. What are the issues that are emerging here, and how is your committee approaching them?
First of all, our committee is studying these issues. Any changes that may come about will come from the Florida Supreme Court. I want to make sure we're clear about that. Bar admissions reciprocity. When we hear lawyers talk about reciprocity, there has been an instinctive reaction. Well, we don't want that, that's bad. And our committee is studying whether Florida should permit admission on motion. There are 2 points of reference for reciprocity. Admission on reference or on motion means that a state will recognize our bar admission, and you can go to a different state and be admitted without taking the bar examination of that state. Reciprocity is a component of that. Reciprocity comes about where a state that permits admission on motion will only permit you to be admitted in their state if your home state permits admission on motion. And so there are now about 39 states that permit admission on motion, and of that 39, 24 require reciprocity.
And as you say, this is an issue that many jurisdictions are looking at now, and it's really developing in that area. I mean, what's interesting is that even in Canada, there's, we call it lawyer mobility, the idea you can move in between different jurisdictions, and that's been catching on and becoming very commonplace now in the last several years as well.
The challenge we face now, I believe, as lawyers is thinking about this issue from a different paradigm. When we first started practicing law, I mean, if you look at your home city, I'm from Tampa. When I first joined the practice in 1987, most of the firms in Tampa, of 50 or more lawyers, were all firms based in Tampa. There are only 2 law firms in Tampa now, 50 or more lawyers, that are based in Tampa. And we have become a profession that is really global in scope, that goes beyond just interstate lines, but also international lines. So I think our challenge going forward is to not go into this with any preconceived notions, but to realize that we're in a new paradigm now, and we want to do what's best for consumers as well, and not just protect our own interests.
Well, and speaking of an issue which comes up in many jurisdictions and has the same kind of idea about cross-jurisdictional competence, the whole area of the uniform bar examination, which again other states are looking at as well. What's your committee thinking in that area?
The uniform bar examination is a fairly recent vintage. It is, the name implies, it is a uniform bar examination that most importantly permits you to have a portable score. And so once you take the UBE in states that administer it and recognize it, your score is transferable. There are now about 14 states that administer the UBE, 2 states on the eastern seaboard, Georgia, and I believe New Hampshire. Most of the states are concentrated in the west. This is something that we are just studying. One of the instinctive issues, the UBE, is, well, if we permit the UBE, then that will denigrate the learning of Florida law. And I went to a conference about 2 months ago in Seattle, sponsored by the National Conference of Bar Examiners, and that particular issue was discussed. And I was surprised by the number of jurisdictions who said that they really hadn't had any issue with training their lawyers. And most states now have modules. It's a 1 or 2 day training course that permits lawyers to gain some state-specific knowledge that those states think is required to be competent under that state's jurisdiction. But again, this is something we're looking at. We welcome your input, but lawyers today want to be mobile. And I think our profession is moving away from one that is parochial to one that is mobile. It's going to cross state lines. And if you think about, our profession, I have been in 3 different firms. My professional life, I've been in a large Florida-based law firm. I have been in a Tampa law firm, a sole practitioner, and I've been in a national law firm. And my suspicion is that our trend, again, is moving toward more regionalized practices. And so, again, it's just something we're looking at.
And Lance, briefly to sum up or to wrap us up, this whole idea of the limited license legal professional, this is something which has already been authorized in Washington State. I know that California is looking very hard at this as well. Can you take us very briefly through what an LLLP or LLT is about and what your committee's thinking is in this area?
I heard you say very briefly. LLT, Limited Legal License Technician. State of Washington has adopted a new form of licensure for legal professionals. These are akin to paralegals, but they're persons who can provide advice to clients directly without the supervision of a lawyer. So far, Washington permits this category of licensure to provide services in the context of family law, but the idea is to bridge this gap that we have in the country of the 85% that are underserved. And I think an additional avenue is also just more competition. I might just go off. And I think one thing we've enjoyed up until this time, which I'll leave you with, is that we have had essentially a monopoly on our services. on how we provide them, on how we regulate it. And we're in a new day and age now, and I think there are going to be more states that will be looking at this and permitting it possibly. We know about the rocket lawyers. We know about the legal Zooms. And when you leave today, write this down, Shake, S-H-A-K-E. That is a legal app that allows you to create legal documents on your phone and do it in minutes and email it to clients, business associates. So we're in a new paradigm now. And so again, this is all part of just new and creative thinking.
Fantastic. Lance, thanks so much for coming. Appreciate it.
Thank you.
So now we're going to hear from Deborah Curtis, who is the chair of the Legal Education Committee.
These were not invented by me.
Yeah, sorry about that. So once again, Deborah, please introduce yourself to the audience as well, if you could.
My name is Deborah Moss Curtis. I'm a professor of law at Nova Southeastern University. I've been a member of the Florida Bar for 21 years.
Fantastic. And fantastic work on you've got 3 steps all set up. It's project management brought live to the committee. Thank you. So the first step, the whole question of defining competencies, I think this is what you've kind of been focusing on for your first year. Tell us a little bit about that process, what you've identified so far and so forth.
Sure. Well, as you had indicated earlier, if you're thinking about the idea of a roadmap, and if you think of legal education as part of a journey, then you want to know where you're going and your endpoint of your journey is. And that's the approach that our committee took, which is before you can say, here's what the journey of legal education should look like, you want to know what people should look like or where you're going at the end of that journey. And we decided to define those as competencies. And we spent a year reading about everything we could get our hands on. Some of the material would be very familiar to almost everybody, like the Carnegie Report, most people have heard of, but all kinds of things. And what we did is we gathered together and we created this 3-part list. And they're not necessarily 3 separate, entirely different kinds of skills, but we, for our purposes, thought about them in 3 different ways. Specific legal competencies, things that we think of as lawyer skills, speaking in court, drafting certain kinds of documents. The second category was general business skills, with the recognition that a law firm and being a lawyer is part of a business. Reading financial statements is a good example of one that's not unique to lawyers. And the third part was more of a professional identities type of skills, project management, time management, organization, attitudes, those types. And we created this end result of where we think people should be at the end of a legal education in preparation for our second year step, which is how do we think about getting there?
Well, exactly, and having identified what those goals ought to be, of course, you know, the devil's in the details, and now we have the whole question of how do we accomplish those goals and how do we get there? And as you put it, what's the range of possibilities here? Because I think you and I have spoken about this before. There's no sense that there's one size fits all. That there's only one way forward.
Absolutely not. There's nobody in the committee who's saying, you know, legal education is now this and now it should be that. The idea is that if you know where people should be at this journey, then there should be this whole range of models in which legal education could better get students to that end. Nobody's suggesting that there is one right way to form a legal education. However, there's a lot of suggestions there are a lot of wrong ways to get there.
Roundabout as well. So in terms of, you mentioned here as well that we're also going to be looking into working with others, right? You know, and recognizing, of course, as the Florida Bar, you have an important voice to play and an important role to play, but by no means are you the only player. Can you identify some of the others, if you will, that you're thinking about and who they might be?
Sure. Once we finish what we consider our second year task of hoping to identify many of these models, the brainstorming, the creativity, we want to bring those models to as many different audiences as we can, to law schools, to the Florida Supreme Court, to the bars, to bars in other states, and to other professionals who might have an interest in working with lawyers.
That's fantastic. Can you tell us briefly, you mentioned some of the competencies earlier that you guys have talked about. Have you, in addition to the ones that you've mentioned, are there any others that you want to make sure that people know about before we wrap up in terms of other?
Well, we do have our whole list, but what I think the important way to think about these competencies is that it is a very broad list. I think traditionally if you speak to lawyers about competencies, we do tend to be too narrow, focusing only on those that are legal. You need to draft this or argue this. I think it's important for people to understand that being part of the profession requires so much more of that broader, especially that third category, that professional identity and attributes aspect, which tends to be underserved in many often in the education field. So,
and I think it's going to be such an important issue. Going back to a lot of the issues that Lance has identified, it's a mobile profession. It's a national and globalized profession and market right now. So being able to have lawyers coming out who have the kind of skills that are exportable and are transferable is going to be key. Well, thank you so much. That's great work, and we look forward to hearing some more about it. Thanks so much. So I want to next welcome Adele Stone, who is the chair of the Access to Legal Services Committee. Adele, thank you as well for coming. Can you also tell us a bit about yourself and what you're up to these days?
Well, I'm an attorney with Buchanan, Ingersoll & Rooney in Fort Lauderdale. My primary area of practice is business transactions and commercial real estate.
Awesome. Now, can you tell us a little bit about the objective? You have an Access to Legal Services Committee. What would you describe as the objective of your committee?
Well, you sort of stole my thunder because your presentation was very much on point, resonated with me in terms of what my committee's doing. But our objective is to ultimately try to provide some form of legal service to everyone who needs it, except that legal service is not to be confused with a lawyer.
Well, yeah, exactly. And there's a tendency to say, yes, there's an overlap between the two for sure, but it's not necessarily a complete identity of those.
Correct. Well, for example, and so many of you have already mentioned it, and Lance mentioned the technician in Washington. We've seen that. We know about that. Limited scope representation. Navigators who assist you with library resources, self-help centers, such as the one that the clerk of the court, Sharon Bach, has put together in Palm Beach County. There are many ways to provide legal services other than through the traditional, if you will, full-boat lawyer.
That makes sense. Now, in terms of that objective, I mean, have you found over the course of the first year that your thinking has evolved in terms of the kind of things you're looking at, that your objective maybe has evolved a little bit over that process, or?
Well, it has, and it certainly should, because you start out with a blank slate, and then you learn an awful lot. There are many, many states and other jurisdictions who have addressed this issue. And I just want to mention that in terms of refining or shifting the objective, we started out with a name called the Delivery of Legal Services / Pro Bono. And as we proceeded, we realized that was from the perspective of the attorney. And what we were really looking at is wanting to have it from the perspective of the client. And we wanted to make sure that we looked at it from access from the client's benefit. We're not trying to tell attorneys how to practice, how to deliver services, or how to price their services. We want to make sure that there are enough tools available, systemic change type tools, procedures, availability, so that clients have some type of access. So yes, we absolutely have shifted and refined our focus.
That's great, and I couldn't agree more in terms of the importance of the client and the end user just being above and all. Now, as someone who loves a good flowchart, I love and I'm intrigued by, and it's cut off a little bit, but it's called Julio's Paradigm. Can you tell us a little bit about this and what's involved?
Well, I named it Julio's Paradigm because my co-chair, Julio Jaramillo, who is an attorney in Miami, was listening to me one day in one of the committee meetings, and I'm going off pontificating about all of these various things that we're doing and the scope, et cetera, and he's writing furiously. And I turned to him and I said, pay attention to what I'm saying. And he gets up and he puts together this paradigm, because this is how he was able to look at what we're trying to accomplish. So, however, there is a typo, and it's how legal services are delivered, not is delivered. We know this. But what this is really starting out with is saying someone has a problem, the client, the 85% that you were looking at. Someone has a problem, and how does it flow down to where they get the legal services? And where we're trying to deal with is the box that the person doesn't know they have a problem, the box where it says they don't know help is available, and the box that says can't afford. That's what our committee is trying to deal with.
You know, and what I love about that paradigm is that very first box where they know they have a problem. And I think it's a really key insight because there's a huge number, I mean, go back to the 85%. That 85%, if you will, can be defined as people who even understand or appreciate that they have a justiciable issue, but there are many other people who have a challenge or a problem or an opportunity, but may not even realize that it exists or that there are legal avenues or solutions forward. So I think that's such a key point to have in there.
Good, thank you.
Yeah. So, so what are your next steps? What's next on your list?
Well, we have a long-term action plan which has 7 objectives and rather comprehensive. And then what we've done is we want to have an early deliverable that we think is within the purview of what we can do. Because what we've also realized in the course of our discovery is that there are many other players in this that we must collaborate with, and clearly the court system, the clerks, the foundation, Florida Bar Foundation, and the bar must get together. But what can we do in the short term? What we can do is look at adjusting or suggesting the adjustment of some of the rules to provide for what you mentioned, which is limited scope representation across the board. Florida now has a rule that allows it in the family law arena. There are many other states, in fact, most states, that permit it across the board. So we're going to be looking at that process and making some recommendations, hopefully by this fall.
That's fantastic. It's such a key area, and you're absolutely right. It is critical. These are the users. These are the people who make the system possible. So thank you so much for your work on this.
You're
welcome. Fantastic. And having briefly compared myself to John Stewart earlier, I'm going to introduce you to John Stewart, who's the chair of the Technology Committee. And John, once again, thank you for joining us and welcome.
Yes, thank you.
Can you tell us a bit about what you're up to these days and where you're working and so forth?
Yes, my name is John Stewart. I'm in Vero Beach. I'm a commercial litigator with Stewart Evans, Stewart & Emmons.
Fantastic. Your technology committee, of course, because technology is just such a vast universe of not just possibilities but challenges as well. And you know, even in that category, there are 5 steps or 5 elements that you've identified. In the time that we have available, can you take us through each of those? This first one, the technology that performs legal and lawyer work. I touched on it briefly, but what are your committee's thoughts on this at this point?
You did, and you know, predicting technology in the future is we're destined for failure, I think. But you know, when you look at technology that performs legal and lawyer work and technology-assisted review, those two really sort of go together. You mentioned, I'll just pick one, you mentioned ODR already, online dispute resolution. People don't realize how much it's already in place. eBay, for example, almost solely uses online dispute resolution. A lot of people use eBay, and if you have a dispute with the good you received or whether you received payment, they resolve those online by using their own in-house staff. These are not attorneys. And to great success, really. Most of their clients are very satisfied with that process. So it's an example of a combination that technology provides, which is disruption with our practice, but also we look at it as opportunities for lawyers to find niches using technology.
Well, absolutely. And I think that's a theme that comes up quite frequently, is that, yes, of course, there are challenges associated with this, but there are opportunities as well. I mean, you mentioned eBay and their ODR system, and they've now spun off that capability into a company called Modria, M-O-D-R-I-A, which is becoming an ODR provider, and there's no reason that lawyers themselves aren't able to take advantage of this kind of technology.
And I was actually looking on my phone. It wasn't that I wasn't paying attention. I was looking at the tweets. You're allowing everybody to tweet, and one of the tweets was, "What's the good news for Florida lawyers?" And I'm hoping that you're the one that's going to answer that question. But assuming that you're not, you know, it's interesting. You know, these are opportunities. I mean, that's how we have to look at them for lawyers. The technology provides opportunities, and when I look at integration of technology into law offices, I think that's one of the primary opportunities for lawyers. You talked about pricing in your presentation, and technology, while is often initially expensive to integrate into your law office, the intention is to bring costs down and therefore bring pricing down and make it more competitive. And we definitely see that the integration of technology into the law offices, I mean, obviously you're seeing it today, is going to compound exponentially over the coming years. to the point that, maybe you won't have nearly as many bricks and mortars offices anymore. I mean, maybe the newer lawyers or more technologically advanced lawyers are going to be working completely virtually.
Mm-hmm. Absolutely, and delivering legal services over the internet, where the lawyer and the client never actually meet face to face, but through the use of technology, a valuable service or product is delivered. So switching from clients a little bit to courts, and courtroom technology, of course, is something we've all been grappling with in the system for a long time. What are your observations in this area?
Courtroom technology, luckily we have on our committee, and we were working with the Florida Courts Technology Commission, which looks at this issue as well. There's an interesting dichotomy. Obviously, there has to be funding sufficient to allow modern technology in the court system, and funding is always an issue that we deal with in Florida and in the legislature for the courts. But that aside, this is an avenue where the courts and attorneys are going to have to be very progressive. The courts are already, this may be a shock to a lot of the listeners, the courts are already in the process of permitting pro se family law persons to come in and actually, in sort of a TurboTax kind of way, fill in their divorce papers for as we look at Adele's committee, for the indigent or those who otherwise don't believe they can afford a lawyer, and process in that way to help alleviate some of the court burden. So there are things, items, processes in the pipeline that are already a lot more progressive than we're aware of, and where it leads us, we're still trying to figure that out.
And that the last bullet there, number 5, the whole course area of work and employment opportunities. Can you just give us some thoughts in that regard as well?
Yeah, I think that that was the group's intent in optimism. You're going to have to find employment opportunities, and I think that there will be employment opportunities. And what's interesting is it all relates, the interrelation amongst these 4 groups, it becomes obvious as you talk about them in this context. And one of the biggest areas that you mentioned is the 85%. And is technology, we believe technology is going to allow us to service more of those persons in an economical way for them and a profitable way for attorneys. And that's how we hope to see employment opportunities. So maybe that answers the question from the tweeter that we had earlier.
Well, you know what I'm actually going to do is I'm going to, because we've actually got a few minutes before our break, I'm going to, and I'm sure you'll be delighted.
Oh, I can take this back.
Sure. But actually, I wouldn't mind even tackling that question myself, to give you my quick thought on, what's the good news for Florida lawyers, or where's the optimism that we should have? And if you guys are open to that idea, I'd be welcome each of you to give us your thoughts on that as well. I think for myself, because absolutely there's no shortage of fairly shocking or not terribly pleasant revelations that come out of all this. Now, I think part of the good news is that whatever the worst case scenario is, I've just given it to you. Right? There's no other bad news lurking under a rock somewhere, at least that I'm aware of. So part of the advantage is now at least we have a sense of what our task is and what our challenge is. So at the most basic level, having a grasp of what our challenge is a big one. The other aspect for me in terms of what's the good news for lawyers, and I go back to this whole question of discovery and e-discovery and so forth. And many of you may have had this experience as well if you worked in a say mid-sized or large firm at any point. But in a lot of these firms, if you're a first or second year lawyer, one of your rites of passage is you're sent down into the basement or into that small windowless room with scores and scores of boxes of documents, and you rip them open and you go through and you're reviewing paper and doing all this over and over and over again. And I mentioned before that computers and machines have gotten a lot better at this. And I think one of the reasons that they're good at this is that compared to lawyers doing it, because think about it, your average first or second year associate, if you say to them, start reviewing documents, they're not trained for it, right? They're not really especially skilled for it, because that's something you went to law school for, right? And they're not especially interested in it either. And so it's no wonder that we tend to not be able to outperform systems that are designed specifically to do this. But I think the larger point there is that there's a lot of stuff that we do as lawyers on an everyday basis, that is not terribly exciting or interesting or challenging, right? It's fairly kind of drudgery kind of work, but it's work that has always fallen to us because we haven't had the tools and we haven't had the resources to have it done otherwise. And where I think the opportunity lies for us is to be able to look at a future in which we can take a lot of this work and say, you know, I'm tired of punching below my weight. I want to be able to assign this out to a resource or a location or technology that can do this work, and I can start applying myself to the work that is intellectually demanding and engaging and requires the kind of analysis and pattern recognition and logic and advocacy that really we all went to law school to be engaged on. So for me, I think that's the good news. We are at the start of a new era, I think, and a new set of relationships for lawyers that will allow us to, I think, become a lot closer to the lawyers we hope we might be when we went to law school. That's my take on it, but I would love you folks, your thoughts on that. Adele, you want to go first? Okay, I have no idea how actually mobile that is either. No?
Is it on?
Oh, there we are. Perfect.
Well, what's the good news? I just saw that tweet. And I think it's all good news, personally, because what we're looking at is we're not addressing I want to use this, the 15%. We're already servicing the 15%. There's enormous opportunity, if you want to be, you know, from our perspective, with the 85%, in the sense that exactly what you said, and that is that we give ourselves the tools to be able to deal with what people really need from us. Let's not forget what they want from us. It's our judgment. They don't need us to do certain things. I work in an environment where this has already happened for years. You have to understand, in real estate, you have many people who cross over into what we traditionally called the practice of law. You have real estate brokers who are preparing contracts. You have title agencies that are not lawyers who are preparing deeds and preparing mortgages and preparing notes, and they're allowed to do that. I mean, there are some states that call that the practice of law, but not in this state. And we managed to live in this environment, and we worked in the environment. So it's all good because, and especially with a limited scope representation, Colorado has a whole manual on how to have a limited scope practice, which is now going to opportunities with the 85%.
Perfect. That's excellent. Thank you. Deborah, Lance, John?
Only thought I would have with respect to this whole concept of the new frontier going forward is that the curtain has been pulled back. And I think probably the most drastic change that has occurred for our profession in the past several years is the internet. And I think it has demystified our profession. And I think that we have to find a way to embrace that. There are going to be new providers in our market, but you know, we look at the medical field, for instance. There are times when, if you've ever been under the care of an orthopedic, you just need to have a prescription refilled. You don't need to wait 4 weeks for an appointment. You can see a nurse practitioner and get the Motrin prescription. And I think there are a lot of things that we do in our profession that we know does not have to be done by a lawyer. Now, it's against our own interest to admit that, but there's no question about that. And there are things that it's just how our profession is based, because it is largely profession based on an hourly rate. And so I think what we've got to do is figure out a way to embrace this. And, you know, if Florida does go in the direction of permitting some other providers of services, it may or may not be within the context of a law firm, but it could be that law firms may have a separate division, which may entail some form of a limited license professional that law firms can do for a profit. And the more judgment-based processes, which we're trained to do, we do in a traditional way. But I think this is a change that is permanent. And then just briefly, with respect to this whole notion of, you know, the last year's 2013 bar survey showed that our members thought the greatest threat to the profession or biggest problem was too many lawyers. And you know, this year we are at about 99,000 lawyers, and you know, I've heard the comment, well, if we open up the floodgates, what's going to happen? Well, states that have permitted reciprocity and have admission on motion, and they really haven't experienced this floodgate. And the other thing to look at is that we are now in a global economy, and think about what benefits it could have for Florida lawyers if we have the ability to do things across lines. And the last thought that I leave you with is, and I'll make this very quick, I was in California, in Washington State with my son about a month ago, and we were going to dinner, and I said, you want to call a taxi? He's 31, by the way. I want to call a taxi. He said, that is so yesterday. What do you mean so yesterday? And so he got his phone, sent a message to Uber by text message, and he was telling me about it. And I said, well, I mean, how do you know what it's going to be? Well, it turns out you can rate Uber drivers. They also rate you. And when you confirm your reservation, your phone shows you a photograph of the driver and what the driver's rating is. And if the driver has 3 stars, you can decline the reservation. And I said, well, when did this all start? And so you say that, I mean, people having, 2 cars in a garage, that's so yesterday. And the reason I bring that up is it just made me kind of think about how I am restricted by what I've always done. And I grew up in an era where, that was the American dream. But to him, having a car is actually an inconvenience. And so I'll just encourage all of us as we go forward and grapple with this to not be confined by what we've always done, because the rules have changed. And I do think that we can either, ride the momentum or resist it. But I do think that this momentum has taken a turn that is not going to go back.
The Uberization of law, exactly. John and Deborah?
Jordan, the only thing I want to say is I was just looking at Twitter again, and the lady who tweeted said, thank you for answering the question. So, problem solved.
Fantastic. Deborah, any closing thoughts?
The only thing I would add is that if you haven't been to a law school lately and the last time you were there was your own legal education, you might be surprised at what's going on there, and as well, more importantly, as to the reception you might get as to your suggestions and your input, and how legal education has opened up and is willing and to work with and understands how it is part of the legal profession in ways that maybe when many of us went to law school, it wasn't. So that's very promising for the future.
And a great point to say that there are so many forces in motion, and there are so many partnerships we can strike and alliances we can seek out. There's any number of people interested in solutions, and I think we can be part of that. We're going to take a 5-minute break, and when we come back, we're going to hear from an expert panel and explore some more of these issues. So we'll see you at 3:45. Thank you to our panel. Yes, thank you, please. Round of applause for our panelists. Thank you. Welcome back. I am very pleased to bring us into the second half of our presentation and our gathering this afternoon. And I would like to introduce you to the members of our expert panel who have joined us to explore some of these issues in more depth. Each of them comes from a different, and I think brings a unique and very valuable perspective to this whole issue of change in the legal marketplace, changing in the shifting realities and the assumptions that we've all been making for a long time as lawyers and practitioners. So I'm going to introduce our 3 panelists. I'll ask them each to speak to you for about 5 or 10 minutes or so to give you their thoughts on what they're seeing and their perspectives. Then I'm going to pose a few questions to them directly up here. And then at that point, we're going to open the floor, both here and virtually. He said looking directly into the camera, and virtually. And we're going to once again remind everybody of the hashtag for this event, which is hashtag FLABAR Vision 2016. And if you're playing the home game, following along at home, please do, and send us your thoughts, your questions that we can bring to the attention of our panelists, as well as those of you who are here in the hall today. Okay, so it is my great pleasure to introduce our 3 panelists. To my direct left is Martha Barnett. Martha has practiced law with Holland & Knight since 1973 and is now a retired senior partner. She served in numerous leadership roles in the firm, including as the chair of the government section and chair of the board of directors. Martha was the president of the American Bar Association in 2000 and 2001 and was the first woman to chair the ABA House of Delegates. So welcome, Martha. Thank you very much for coming today. Chidi Ogini is the interim dean at the Florida Coastal School of Law in Jacksonville. Chidi has previously served as the General Counsel of Infolaw, where he oversaw regulatory affairs, compliance and governance, as well as transaction execution. He was also a partner with Gilbert's and an attorney with Sullivan and Cromwell in Washington, D.C. Welcome, Chidi, as well. And David Hazuri is the Managing Director of Miami Lex, a subsidiary of the global legal process outsourcing company United Lex. David is an 18-year litigator who started his South Florida legal career with Shook, Hardy & Bacon, subsequently becoming a partner at Bills & Sumberg, Bain & Price, and Axelrod, and I hope I got all 5 of those right.
You did.
And in 2006, David started his own e-discovery company in Miami, and then returned to practice with the law firm Shubin & Bass, PA. Welcome, David.
Thank you.
And I'm just delighted. I can't wait to hear what our panelists have to say. Martha, if you would open up for us and give us your thoughts.
Thank you so much, and I want to just personally acknowledge our President Pettis for having the vision to create a program like Vision 2016. I think it takes a lot of courage to actually open up the kimono on a profession with the traditions and the longevity that ours have, and be willing to ask hard questions during very difficult and amorphous times. So I want to thank the President and the panelists so far. This has just been a fabulous presentation. It puts me in the awkward position of not having any idea what to really say, being the last panel and the last hour of a program on Friday afternoon, because so much of this is a complex subject, and so much of what I would really mention to you or has already been covered either by the keynote or by the panel members. It is a complex, changing environment. So what I thought I would do is just briefly talk to you a little bit about the perspective of a practicing lawyer. You got a clue as to how long I've been practicing law when you heard the date 1973. That's 40 years that I've been privileged to be part of the profession. And to just give you maybe an anecdotal example of some of the things I've seen in my practice over the last several decades that would fit in to this overall discussion. There are a lot of players, a lot of interdependent players in this particular discussion, a lot of shareholders and stakeholders, and there's often a lot of tension that develops between those various stakeholders, lawyers, and being a good student, everybody else who's not a lawyer. There's a lot of tension that sometimes exists, whether it's in legal education between the academy and the demands of the practice of law and lawyers and law firms, or whether it is reciprocity or really the reality of what the practice of law is today and the way people actually do business as professionals, whether it's in the area of alternative business systems or the law firm, the traditional law firm settings. There are a number of tensions. There's a long list of those. There have been a lot of things said, and there's a common theme that has developed, at least in my judgment, throughout all of the comments today, and that is change. Change is scary. Change is hard, particularly for an institution like the legal profession, which does have a long, proud history that spans the continents, not just our particular experience with democracy. But it's a given, it's incremental, and it's constant. And the current economic situation has only highlighted some of the changes that have been in place for decades, literally for decades. The recession may have accelerated our attention that we pay to some of this change, but these are things that have been coming for some time. I'll just give you one perspective from my personal point of view. The most obvious visual change I've seen since I started practicing is the number of women who practice law. When I graduated from law school, less than 10% of the law students of the profession were women, and today we're approaching 50%. For those of you who heard Fred Gray yesterday, this idea of who practices law still has a lot of change left to be accomplished in the whole area of diversity, and I know the bar is looking at that with separate programs, but I mention it here because it fits into one of the areas that we are looking at, and that is the delivery of legal services, particularly to the underserved and those who are under lawyers and underrepresented, because who provides those services clearly impacts the people that need those services. And so that is something that, as I said, this is interrelated, and that's one of those things that, while it's a separate topic worthy of lots of discussion, it's integral, I think, to some of the things we're doing. So, in my role as a lawyer, I have had the opportunity to work in a local law firm, same law firm, local law firm that became regional, that became national, that became international, and to be part of building that institution and the challenges that young lawyers, senior lawyers have in accommodating the changing dynamics of client loyalty, going from institutional loyalty to almost isolated, specialized use of lawyers. And it's been, for me, rewarding. I'm excited about the change. I'm optimistic about what it means for us as a profession. I had one experience, and I'll just talk about one area of our four. I had one experience with a client that opened my eyes in a way that I don't think it otherwise would have to how positive and empowering change could be, and that's in the area of technology. It's been said already, but the internet really did change everything. The internet is a generation-changing event. It's been around 40 years, I think, maybe longer than that. It's only recent that we are beginning to see the power of it. And I had someone call me one day, probably 20 years ago, and the first question they asked me was, would I help them get driver's license information? And I said, you really don't need a lawyer to do that. It's a public record. You can get that on your own. They said, no, they won't give it to me. I said, well, it's a modest cost for it, but it's pretty simple to do. He said, no, I want all of them. And I thought, how many do you have? And he was saying something, I was hearing something else. It turns out this individual wanted me to get all of Florida's driver's license records for everybody, historic, for everybody. And I went, now that I can see might create a problem. This was 20 years ago. It was the first time, other than R.L. Polk, who has vehicle identification numbers, that the Department of Highway Safety had ever had anybody ask for all of the records. And I spent the next couple of years helping this individual accumulate public records and other private information that he could buy, and then ultimately what you could scrape off the internet, and created data systems, one of the first database management companies that was done. Today, big data is a buzzword, but 20, 15, 10 years ago, people were just understanding the power of billions of pieces of seemingly insignificant information about an individual, an activity, a company, and how powerful that could be, and what a powerful tool it could be for lawyers, for insurance companies. I got the golden hook. For the insurance companies, and I raise it with you because it's an example for how we can take technology and not be afraid of it, but use it. This client ultimately sold that company to LexisNexis, and the kinds of services Lexis advertises in this Brochures in our materials are things like client and document management, billing and accounting records, software solutions, how to organize and manage your firm, how law enforcement can find criminals, online child pornographers. The power of that tool is dramatic, and that is being replicated time and again. And for us, our challenge is to use those to do the things that technology can do and to preserve for lawyers what we traditionally have had a monopoly and actually really the support of the public in doing. So that's why I'm optimistic, just using that one example. There are a lot of things, though, and I'll close with this, there are a lot of things that should not change. I brought with me, in fact, I keep it with me most of the time, I have the Constitution of the United States, and I refer to it on occasion, I treat it like a passport, because in the preamble there's something that I like to keep in mind, and it says, "We the people of the United States, in order to form a more perfect union," and we list a number of things, but it says establish justice. What this is all about and what lawyers are all about is justice. So as we go through this dramatic, cataclysmic, disruptive period of change, the things that cannot change are the unique roles that we have in commitment to our clients, loyalty and duty and commitment to the clients. The other is our sense of public service, our commitment to the public and our ability to serve the public, and ultimately to the independence of our profession, and to provide those things that only using our intellectual capital and our unique training and analytical skills that we can do that Watson, for example, cannot do, even though he can win double jeopardy. Only to do those for the unique things we can do, and I think we will be more successful as a profession than ever. Thank you.
Martha, thank you very much. Chitty.
Thank you very much, Jordan, and to President Pettis, Mike Garcia, and my fellow panelists. Like my dear friend Martha, I fear that I don't have much to say because obviously in the run-up to this panel, Jordan and the other panelists touched on a number of things that I was going to speak to. In particular, I want to commend Lance for mentioning the Uber reference. I think you stole that from me, but I was going to make the point that Lance just made, which is analogizing Uber and taxi cabs to lawyers and I'm afraid I have to use the term, non-lawyers who are looking to disrupt us. So let me just start out with a few thoughts, and then hopefully we'll get more into it in the interactive part of the discussion today. One is Jordan introduced me as the interim dean of Florida Coastal School of Law, and it is true that is exactly what I am. I am the interim dean at Florida Coastal School of Law, but I've only been in the role, in an academic role for just about a year now. Everything prior, the past 20 years of my life, I've been a practicing attorney, first in Nigeria and then my country of origin, and then when I came to the States and got out of law school at Sullivan and Cromwell, and then a number of other forums. Most pertinent to today's discussion is that immediately prior to becoming the interim dean, I was the general counsel of Infolaw, which is the parent company of Florida Coastal and a number of other schools. And it was in that context that I had a profound shift, because I went from being really a purveyor of legal services to being a purchaser of legal services. And being on the other end of that, I saw a number of trends that concerned me. This all came to clear focus for me when I think I just attended, I think it was back in 2010 or 11, and I just come from the Association of Corporate Counsel meeting, I believe it was in San Antonio, and as is the case today, there were vendors outside hawking their wares, and as I passed one of the booths, they gave me a book a complimentary book, written by a fellow by the name of Richard Susskind. And I'd never heard of Richard Susskind, so I was, the book was of questionable value to me, but they pressed it upon me, and it had a very intriguing title. It was called The End of Lawyers, with a question mark. It was a very provocative title, so I secreted it into my bag and resolved to myself that I would read it on the way back to Naples, Florida from San Antonio. And I did just that. It was probably the most important thing that I have done in my legal career was read that book, because it made a number of things really come into very sharp focus for me. All the things that I had been grappling with, how I had gone in one fell swoop from advocating for a higher billable hour, billable hour requirement, more billable hours, to being on the other side of it and saying, no, I don't want, the last thing I want is the billable hour. And the tension, if you will, between bespoke services and commoditized services, and how do you sort one from the other? All of that really came into very sharp relief for me, and so that has been helpful to me in my career. And I'll just touch on a few examples. One of the overarching thoughts that I have is that we are oftentimes our worst enemies, because in many ways we act as a guild, and the guild has been good to us. It's been good to us for a couple of 100 years. But I think we're at the point now where the guild is really starting to disserve us, and we can see that in very tangible ways. One of them is that as members of a guild, I think we have lost the ability to relate to people who are not members of the guild. And so, for example, our company was sued. We had a class action lawsuit filed against us, and we had retained counsel to help us with the lawsuit, and they were going to brief the CEO and the CFO on the development. So I had a pre-call with them, and I said, "Hey guys, you're not talking to me now. You're talking to the CEO and you're talking to the CFO. And these are smart guys, but they're not lawyers. So, drop the jargon, just talk to them as you would a normal human being." And the guy says, "Okay, I got it. So we get on the call, and the CEO says, "So what's the complaint about?" And our outside counsel clears his throat, and he says, "The gravamen of the complaint is," and then after that, it was just it went downhill from there. So we have got to learn, and I think when we talk to ourselves too often and we don't incorporate outside voices, we fall victim to I think it's the Pauline Kael theory, which is the notion that how could anybody have voted for this person who won the presidency, because everybody I know didn't vote for him. Well, you're only talking to yourselves, so it's very incestuous, and you're not really incorporating outside views. And that's, I think, one of the reasons why we've just gotten gobsmacked at things like the $458 million investment. When did that happen? Well, how did this happen on our watch? Because we were so busy talking to ourselves and being preoccupied with internal matters that we didn't really incorporate outside perspectives. Another thing, I think, where lawyers disserve themselves is that when they pitched me as general counsel, they would always lead with, "Well, I'm an expert on this." I said, "Yeah, you're an expert on this? Yeah. How many trials have you done?" "Well, I've done at least a couple of 100 trials, and my partners together we've done thousands and thousands of trials." "Okay, great. So what's it going to cost me?" "Well, I don't know, because it's imprecise. It could go this way, it could go that way." But of course, if you would never accept that from any other vendor or expert. You would say, "Okay, use your experience, your base of knowledge, to estimate for me, how much this is going to cost." And you would have a normal distribution, a bell curve, and you'd be able to say with some precision what this should cost. We don't do that, and as a result of that, clients are fleeing in droves. The third thing that I want to touch on is the acute need for the practicing bar and legal educators to be singing from the same sheet of music. If we do it right, there should be a virtual feedback loop where law school legal education is being informed in real time by what practitioners are experiencing out in the field, looping that back in for the benefit of our students, both prospective and current. And that is getting better, but there is still a significant gulf, too significant in my view, between what we do in law school and what you all are doing out there in practice, whether it be traditional forms of practice or alternative forms of practice. And so consider this my plea to all of you to please get involved in efforts to make sure that that virtuous feedback is taking place and taking place in real time. And then I hope we also have the opportunity to touch on some of the other issues. Thank you very much.
Chidi, thank you very much. David.
Thank you, President Pettis, Mr. Furlong, panel members. I feel like as a representative of the outsourcing community, I'm something of Exhibit A up here. But be that as it may, what would be most interesting for you to hear is something of the story of Miami Lex. As you've heard, I'm the director of Miami Lex after being an 18-year litigator here in Miami, Florida. And what Miami Lex is a partnership of sorts between United Lex, which is a global LPO, legal processes outsourcing company, and the University of Miami School of Law. And the story starts with what is the current status of a lot of law schools right now, running at 85% around the nation at deficit. These are falling admissions results that are in due large part to the current legal market and the effect that it's had on admissions. And Dean White, Patricia White of the law school, had the foresight to determine that what the law school needed, rather than to lower standards to maintain current, or 2006 admissions levels, was to appropriately respond to market conditions by reducing values, reducing admission numbers, and looking for other sources of profit that didn't require the deployment of revenue. And she had the foresight to reach out to United Lex to look for a partnership that says, is there an opportunity here for us to co-brand, allow us to use the power of our relationships with JDs in the community to provide you the opportunity to pitch services. And our services in this instance would be most likely the e-discovery vertical, where we would provide the soup to nuts sort of e-discovery solution, and allow the business go forward under that co-branding. The results would be, there would be something of a revenue share going back to the University of Miami under the terms of something like a licensing fee. And then there would be this other option, this other component to it. The other component would be that we would give preferential employment to recent JDs coming out of the University of Miami who would operate within our company as project management level oversight employees handling contract review. So contract review is a component of our services. So what you had both was the ability to drive revenue back to the law school, right, without any out-of-pocket for the law school. The fulfillment of the services would come from the LPO, which is United Lex, right? There's no out-of-pocket for the company, the school in that respect. And then there would be developed an externship for JDs coming out that would get training. And training would be specifically in what I think is a very important component of what we're seeing in the changing legal market, which is project management skills. All right? My first couple years in large law firms was very much like a discovery experience with documents, and then later on started to become more computerized. All right? That is certainly as good as an experience as they're getting with us at Miami Lex, and because they have oversight where they are able to interface with the clients in some respects to understand what the standard issues are, escalate issues up when they come from the contract review attorney workforce, and solution through the entire life cycle of the discovery component. They have a value add when they then want to go out 2 years hence and look for jobs within law firms, and what we're seeing in some instances directly into the corporate environment, because corporations now are starting to see the value of bringing law students in, since data management and project management flow is such an important part of what they're doing, rather than bringing in people from 5, 6 years, maybe having some litigation experience right in, bringing them right in and having them become experienced with their business flows, with their efficiencies, with their models, and with their particular profiles, so that they can build from within. So that is the Miami Lex story that is now going forward. We've been moving this forward since about September, and for the United Lex, which is the parent of Miami Lex, it's very gratifying to remain within what we call the legal ecosystem, because what we are 1,800 professionals. 20% of us are engineers, but the other 80 are JDs. And rather than having these outsourced, being the outsourced company that takes this segment of the legal processes completely out of the legal environment, and controlled by technocrats or the latest app developer, we as attorneys still have our hand in it. We are integrating what we believe will be the next generation of lawyers who understand the importance of project management flow to this process and to the delivery of legal services in the future. And in that respect, that's how it stays in the legal ecosystem. My sense is, why is that important? The sooner that lawyers are shown the door in this process is the sooner those processes become completely commodified. And while there may be an appropriate level of commoditization for some components of the legal services, for the betterment of delivery of legal services to that 85%, there is still always going to be a place for attorneys to provide the best type of legal services in just about all components of what is currently our legal market. So,
awesome.
Thank you.
Thank you much, David. So I'd like to run a few questions by our panelists, and while I'm doing that, if you have questions of your own that you'd like to start preparing, we have a microphone here which will take them, and we've already got some questions via Twitter, and I'll run them past later. But until then, Martha, I want to start the first question with you. Given your leadership of the ABA, and given that we're here as part of the Florida Bar, what role do you see for bar organizations? I mean, we talk about all the everybody's got a part to play and everybody has a role they can bring. From bar associations, bar organizations, what do you see is their best role that they can play in this process?
I think there are multiple roles for professional associations, and I'd maybe divide it into two aspects. One is the regulatory, the self-regulating that the bar itself has, but the regulatory in terms not only of accreditation of law schools, setting standards for accreditation, but also the professional standards, the Code of Professional Responsibility, the Code of Judicial Conduct. I think that aspect of it has proven to be very beneficial to the profession and to the public. The collegial aspects of it, the opportunity to come together in a meeting like this and discuss very important issues. The other role I see for bar associations, and the collegiality is probably part of that, is the aspirational goals. The goals to maintain the profession as a profession, recognizing that increasingly the business aspects of the profession are becoming critical components of people's decisions to practice law and how they practice law and in what format. So there are multiple roles for professional associations. The challenge for voluntary bars, as opposed to an integrated bar such as the Florida Bar, where you have to be a member to practice. The challenge for voluntary bars at the national and local level is to be relevant and to find ways to actually provide relevance to the people that you are hoping will think you are important enough to what matters to them in their profession that they will actually join. And that's a bit increasingly tough challenge in today's world.
Thank you. Chidi and David, do you have any thoughts on that question yourselves?
Nothing to really add to what Martha said.
David, any observations?
No, I think Mark covered it.
Excellent. Chidi, I do want to start the next question with you, and this is something I think all of you will have an interest in. But given we talk a little bit both in Deborah's presentation and a lot of the issues that are underlying all this, the whole area of legal education and law school, and there's a tremendous amount of upheaval there. Given all of that, from your perspective, how can law schools and law professors do their best to prepare the current generation of law students, aspiring lawyers, prepare them for the future of law practice?
It's a great question. Thank you for asking it.
You may want to pull the microphone just a little closer, sorry.
Can you guys hear me okay? Okay. So I would split it up into three components, if you will. I talk about current and prospective students, and then talk about the administration and the faculty at the law school, and then finally talk about some of the more technical aspects, the curriculum and the pedagogy, if I might. As it pertains to current and prospective students, I just don't think that we have done a good job of educating them on the opportunities that are available to them in this new normal. So I think they see the disruption taking place in the 15%, and they say, well, law school is not for me, or I'm spending too much compared to the value proposition that I'm getting back. And the traditional response has been, look over the entire arc of your career, and when you look back, you will find out that law school have been worth the investment. And I think that there is some merit to that argument, but I don't think that we're meeting the students where they are to make that argument, because I think, whether they know it or not, current and prospective students are implicitly thinking along the lines of, what was the line by the famous economist Keynes, who said, in the long run, we are all dead. So you're not going to look over, you've got to address the value proposition right up front. And I think to the extent that we say, look, yes, there is disruption at the high end of the market, but if you will, look below the surface for that 85%, and you've quantified it, and that's hundreds of billions of dollars annually. And if you are trained in these ways, then you can take advantage of those opportunities. You can write your own ticket, essentially, in some of these fast-growing careers. And that it is with that perspective in mind that we launched the Center for Law Practice Technology at Florida Coastal last year, where we are teaching our students about document automation. We are teaching them legal project management, e-discovery, et cetera, and giving them certificates in said orientations so that they are that much better equipped to compete when they graduate from Coastal. The next component is the administration and the faculty. And I think there it's just a classic change management issue. For a number of the faculty, and I say this without disparaging them, what this new normal entails from a curricular and pedagogical perspective is very different than what they thought it would be coming in. Yeah. And so what you've got to say to them is, it's one thing to say, this is for the betterment of the students, and I think a lot of them resonate with that. But I think we also have to address, how is this good for me? And I think the answer to that is, to the extent that this is what people are looking at in terms of, this is the new value proposition for students, and you are the person opening the pathway for them to do that, you have enhanced your job security. And so I think having that discussion with the faculty in an open and transparent way is frankly the only way that we're going to be able to get there. And then really quickly on the curriculum and the pedagogy, I've talked a little bit about things that we're putting in, interlacing into the curriculum and embedding at a very granular level with the Center for Law Practice Technology. And it's my hope that it will cease very soon to be a standalone thing and instead become embedded in the curriculum. So for example, you don't have a separate e-discovery module. E-discovery is incorporated into an evidence course. You might have specialized courses, of course, piggybacking off of that, but that would be the intent. The pedagogy is, I think, where there needs to be a little more work done, in the sense that it's not sufficient to me for a student to come out and tell me, I'm proficient at legal writing, I can write this motion. But if I ask you to assemble exhibits for said motion, and you don't know how to do it in a technically proficient way, and you do things like, and I see rookie mistakes like this all the time, where instead of printing something to PDF, they will print it in Word or Excel or whatever, rush over to the printer and convert that to PDF. That's a rookie mistake that should never be tolerated in this day and age. And I really do believe that it is incumbent on us as legal educators to interlace that sort of instruction together with the substantive instruction.
Fantastic, thank you. David, I'm interested in your take on this as well, because of course there's a close law school affiliation in your line of work.
Yeah, I mean, there certainly has to be something that that changes in respect to the curriculum that has a value add for immediate, so that they can hit the floor running in law firms, because there's such a devaluation of the first, second, and third year capability right now in the traditional law firm practice that, one of the obvious ways is I think as Chidi was saying, add components that give outcoming law students project management experience, understanding what the new paradigm is, make them aware that there is a very, very real challenge in the traditional business entity that is the law, the legal law firm, and maybe even challenge them not only with learning about the various business models, but something along the lines of almost like a business school type project where they ideate about how do we start to look at different opportunities here that are outside what we've been told we're going to see otherwise, which is the law firm I'm trying to internship for this next summer, or the corporation I'm going to do the unpaid internship for at a very small level.
All right, thank you. Martha, do you have some thoughts in the area?
Just one of that relates back to the role of bar associations. One of the functions that is housed within the American Bar Association is the section of legal education and admissions to the bar, and it is authorized by the Department of Education to actually be the entity with some authority, approval authority from the ABA, but it accredits law schools, and it's pretty rigid in the standards and the implementation of those standards for law schools, and it's under a lot of scrutiny now because of concern that the standards are not meeting what the real academic professional needs are for the students once they graduate. And one recent within the last couple of weeks, one recent decision that came out of the section of legal education, which goes to this idea of adding coursework for clinical, experiential education so lawyers can be more practice ready when they get out of school, have a better chance of getting a job. It's a simple little small area, but it's illustrative of the importance of the bar, is that it will not give credit for law students who participate in a clinical work that is paid. If you get paid for it, you don't get credit for it. There's some idea that money somehow taints the academic impact and the clinical educational impact. And I think that we're moving into an era where all of our institutions, and particularly accrediting associations, et cetera, have got to be realistic about the impact this is having on the students who are going to become lawyers. And so that would be my comment on that.
You know, what's interesting is, and Dave, this goes back, you mentioned business schools and the approach that business schools take, and I think there's always been a lot of things that business schools do that law school could take note of. Well, what's interesting, I read an article several months back talking about how even business schools are now coming under fire for the fact that they haven't kept up with the current needs, and a number of people actually laying a fair bit of the blame for what happened to our economy over the last several years to how MBA programs have been developed in training people and so forth. So it's interesting that even a group that we are thinking we might want to follow ourselves at some point are also running into this issue. I got one last question, which I'm going to start with David, and then we're going to open the floor. And David, that's because I want to talk a bit about alternative providers, non-traditional sources of legal service. And you've, like Chidi, you've had the opportunity to be on both sides of the area. What do you think, what does the future hold for non-traditional providers of legal services from your perspective?
Well, I don't have as broad a knowledge as you do on all of those particular models, but I'll speak to what I know perhaps best, which is the outsourcing that we're providing directly to law firms and companies. And when I started in 2006 with my own little e-discovery company, the big issue was data and dealing with data and the complexity of business applications as litigators had to deal with them on behalf of their clients. And so we were focusing on solutioning for data. And I found in the course of solutioning from the technological side, a lot of my time spent as the attorney part of a two-man team was actually solutioning for attorneys, first of all, understanding how to handle it in the context of their discovery life cycle, and then ultimately helping them put together the pathway from getting to A to Z. And I didn't realize it at the time, but what the challenge was there was they did not have any kind of project management mindset to what was a complex, process that had lots of opportunities for making bad decisions and lots of opportunities for making very good and efficient decisions. I got back into practice and practiced for 5 more years before I took this position, and I come back, and what is happening is there are lots of companies, much like mine, that have feasted on the fact that in that interim, nobody has taken up the call of better processes, better project management. Some firms have. There's definitely some of the larger firms who are going to see the volume and have the volume to then make larger decisions in terms of how do we deploy our revenue, do we bring in an outsourcer, can we actually own this piece because we can maintain the cost and justify it because of the work that's going to keep it busy. But in most instances, I can still go into a law firm sometimes and it's 2006 or it's 2001. So what we're dealing with today is the data is not getting any smaller, it's getting bigger. The complexity of the environment that businesses are operating in, and I'm thinking mostly commercial, but not exclusively, is getting more complex, not easier. Some solutions are there at the enterprise level that looks forward to e-discovery happening in a company, and that's great, but it doesn't cut across all of the issues that are there. So the challenges are finding assistance in dealing with both the data size and becoming more efficient. And that can mean owning it inside, like I've said, where a law firm has the software, owns the uploading and the hosting component of it. The problem there is you've got to have the people with the technology and the know-how and the ability to scale it up or down to handle that. The other is to actually have a managed service relationship, which there are plenty of them out there, including Miami Lex, that works with you, owns the technological piece, gives you the platform to work with, and but again, there can be a cost associated with that sometimes surprises law firms. Then there's the larger pieces where you can have a company come in and own the entire back office operation. In that instance, it actually operates within the law firm, and if there's sufficient oversight, the law firm can rebrand that and then tout to the clients, we've got this significant amount of scalability, our processes are ISO 2700 compliant, and that becomes a selling feature. My concern is for those mid-level law firms who may not have the volume of the large law firms to sustain this. And to me, I keep running against that. It's difficult to go, okay, I'll give you tiered pricing. We'll try to do solution as a software, which is something you hear sometimes where there's a partial ownership of the hosting component of it, but the company stays there to manage the upload. I think unbundling and getting the price point for their services away from the hourly cost is the way that those companies are going to have to do it, because they just don't see enough volume, and yet it's still critical to their delivery service.
Okay, so. Thanks. Okay, Martha and Chidi, further thoughts on non-traditional alternative providers of sources, the services?
Only just an observation that I think one of the biggest threats to non-traditional providers of legal services are we're seeing in the UK and Australia and other countries, not right in the US right now, but coming from the big four accounting firms who basically are practicing law from, Walmart having law shops in the building. There are lots of different models developing from businesses who are in it for a profit motive, and they have systems in place to pick up on the comments made. They have systems in place. They have the business planning mentality that has proven enormously successful for them in other areas, and they're going to apply that to the delivery of legal services, and they're doing it, and doing it very effectively in other areas.
Okay. Chidi, any thoughts?
Yeah, I would just say that
from my perspective, I think it's a pretty good bet that alternative service providers will follow a classic disruption path. Right now, they are starting at the low end, the commoditized work, but when they get, as they get more experienced with what is happening, they will quickly march up market. So from the perspective, from our perspective as practicing lawyers, it's incumbent on us to recognize that, and there are two ways in which we could react to that. We could say, let's try to make the yield barriers that much more higher, that much more severe, or we could, and this is the path that I would recommend, the more prudent path would be to say, okay, we know that over some time, the U.S. is going to follow a path like the UK, like Australia. Let's use this time now to get into pole position, because when you really dissect it down, I think you'd be surprised to find out how much of sophisticated legal practice is actually the practice of law. A lot of it is just really project management and process. So if you can learn that and equip that with the legal skills, the substantive legal skills that you bring to bear, then I think you have a good chance of prevailing in this new paradigm. But if we don't do that, and if we fight and fight and fight on the UPL basis, then we are sowing the seeds of our own destruction.
Okay. We've got about 15 minutes available for questions of various kinds. So I've got a bunch here online, but we'd like to start with what we have here in person. Sir. And sorry, if you could identify yourself and, yeah, awesome.
I'm Nathan Aronson at the University of Miami School of Law for a few more weeks, and then so I'm at the very end of law school. And regarding law school, one thing that I haven't heard discussed is something I think is just as critical as the legal market has contracted, and there's the new normal that everyone is facing, and that is that law students are facing going into the market with a level of work demanded from them at law firms that is almost inconceivable to me. And that's, I think, somewhat being reflected in the law schools now, in the level of work that is piling on in the classroom. And I'm seeing a lot of my friends and a lot of colleagues that I think personally are suffering as a result of this restructuring of the economic market. And for established attorneys, this is obviously uncomfortable. You're making less money. It's difficult to run your business. But I don't think, you are experiencing the critical personal sacrifices that I think an entering first-year associate is going to experience now, or a law student who's struggling to network and establish himself in the legal market right now.
Okay, I would invite, by the way, this is not just for our panelists, any observations anybody would like to bring on that point, by all means, please do. Oh, sorry.
I think you mean billable hour requirements. And I have to tell you, I'm practicing 36 years. I started out with a small firm, and I've moved up in the ranks. I'm now with a national firm. Billable hour requirements of the magnitude you're talking about have been around for a long time. And there's been a lot of discussion about the fact that what it does, it creates a problem for what you said, having to go out there and become active in the community and drum up business, and also bar activities. It's very difficult to volunteer time for the bar. I think, I think it's being discussed, but the tension, quote unquote, is between having to make the bottom line with those billable hour requirements. And by the way, again, I'm practicing 36 years, and I have some pretty heavy billable hour requirements myself. So I don't think we're here to solve that problem. I mean, I don't think any one of us on this panel can solve that problem. It really is a marketplace problem, but I think that it is recognized, especially in the pro bono arena, where we're demanding, not in an official way, but we're asking more pro bono hours, and it's difficult of the young attorneys who have those kinds of demands on them for billable hours.
Thanks, Adele. We can do one more comment, Martha?
I wanted just to say that you add to that the debt load that students carry when they get out of law school, which I think exceeds anything in my experience in the last number of years practicing law, and that the problem just accelerates because I think people feel their choices are limited and their options are limited to do anything other than, if you get a really good job, you've got to stay the course. But the practice of law has never been for the faint of heart. It's a tense, exacting profession, and it impacts career decisions all the time in a large law firm where people simply choose, if they have the luxury of doing that, a different lifestyle based on quality of life issues.
Great, thank you. Yes, sir. Oh, well, actually, this gentleman's up first, and then...
Hi. Ted Small. I'm a solo practitioner over in DeLand, and I'd like to underscore a point that was made earlier by Martha and somewhat also by the Dean. And that is that sometimes we compartmentalize a little bit too much as we're trying to solve problems. And diversity, I have found in my change from being in a big law firm, going to a solo practice in a small town, makes a huge difference in terms of access to justice and access to legal services. There are some matters that are brought to me I have absolutely no competence in. My billboard, my signage has nothing displayed that says I do that, but they come to me because I grew up there. They know me, they feel comfortable with me, and they tell me, frankly, there's nobody else. I don't care how many other lawyers out there that we will allow to handle this case. So translating that, so there are plenty of things we can do in terms of rule changes, in terms of technology, in terms of how we train lawyers. But one thing we must also do if we want to make a difference in terms of access to justice is to roll out this diversity prong in huge order and make it a part of that discussion so that we have more lawyers who look like the potential clients that they can access. So one question I have for you, Jordan, is we are doing a lot with this 85% or 80% unserved. And, a lot of that depends on, that data. And I'm wondering whether that is just data that is brushed across the entire nation, where you're really looking at, the aggregate, across geographies. Have there been any studies that have actually looked at places where you have a high percentage of minority lawyers, diverse lawyers, serving the population, and whether that percentage goes down significantly?
It's an excellent question and an excellent point. I haven't seen any data like that. I haven't seen the studies that have come out now that have looked at the whole issue of access to 85%, to my knowledge, have not dug into that. Now, there's people here who are more expert at that than I am, so if you're aware of these kind of studies, I would encourage you to let us know. But I think it's an excellent point, and it goes to, and one of the points here, it underscores, I think, also the importance of trust. Right? Because that's one of those things we trot out on a regular basis and say, oh, well, trust is the core of the relationship between the lawyer and the client, and it's absolutely true. And trust is engendered in a whole bunch of ways. A lot of it is community-based, in communities defined in a number of different ways. So I think it's an excellent point and a good way to think about, and a good perspective and angle to bring on the whole access issue. Chidi, have some thoughts?
I'm in. I am not aware of any studies that look at it from the supply perspective. But I have seen studies, and I meant to look at one before I came into the session, and I ran out of time. But my recollection is that they did it on a jurisdiction by jurisdiction basis, and Florida is one of the most underserved jurisdictions. I think it's probably in the top 5 or 7 from the perspective of demand versus demand versus effective supply. And a lot of that is driven by diverse communities where there is not, in fact, a lot of diverse representation. And that is one of the explicit aims of Florida Coastal School of Law, to help diversify the legal profession. So it's something that we're very, very attuned to. It's one of the reasons why a founding course at the Center for Law Practice Technology is Access to Justice and Legal Technology. How do we get our diverse lawyers coming out of Florida Coastal out into these communities and serving them using the tools that we provide them to lower the effective costs so that they can provide the services that are so desperately needed. So.
Okay. We can do one more, if it's really quick.
Okay.
We can do one more question from the floor.
I'll try to make it quick. My name is Nathaniel Burke, and Mr. Furlong, I really did appreciate your slideshow. Particularly the idea of that 85% unknown change coming. It's a little scary. It's also very exciting. I recently read a book called Who Owns the Future, and it's by a guy by the name of Javier Lanier, who is a fantastic musician, but he's also one of the hottest IP guys in the world. And basically, he says technology owns the future. And the people who have access to the fastest technology own the future. The people who have the access to the fastest trades on the stock market are going to make the most money, and they're going to progressively make the most money, while those who do not have the money and the access to the technology are going to get progressively poorer. And what I've been hearing a lot at this seminar is, you know, what are we going to do as professionals about our futures? And what I haven't heard a lot is, what are we going to do about our less fortunate clients' futures, and how we can use this technology to invite the people, the quote-unquote illegal immigrants, the accused, the vets, the mentally disturbed, the abused spouses. How are they going to get access to all this hot stuff, technology that's coming down the line?
It is a danger, isn't it? And it's a problem when we face the specter that technology just ends up being in the hands of a few. What I've been seeing, which I think should be encouraging to your concerns, is that a lot of the technology that's now being rolled out is actually being rolled out in the access area. I'll give you a couple of quick examples. And when I say the access area, I mean go to markets that are not normally tapped or that have difficulties. At Chicago-Kent College of Law, they have a program there called A2J Author, and it's software that essentially creates programs by which people who are not in a position to hire a lawyer, they can almost like walk step by step through a legal process. It's got a graphical interface, it's a little pathway, and you can come along as you go along. And a lot of schools have looked at this, but if you're interested, I would encourage you to check it out. Chicago-Kent Law doing a lot of really interesting things there. Another company I want to point out to, I mentioned expert applications earlier. There's a company called Neota Logic, N-E-O-T-A. And they are the leading provider in this area. But Neota also has a very strong interest as well in the whole area of access. One of the things they do is they set up this arrangement with the Georgetown Law School faculty, where they have a course every year called Iron Tech Lawyer. Right, and they have a competition around this. And law students are actually programming apps to answer various legal questions. And they have a competition it's amazing to see some of the apps that get rolled out. One, I remember, was one that was in charge of, it basically answered questions about same-sex marriage in all 50 states. Another one it was a question, are you a US citizen? I think it was called US citizen or not, or something like this, right? And the idea is that you can register and use this. I think there may have even been one on veterans benefits, although I'm not entirely sure. So the technology is there to actually allow us to roll out and do these things. So in that sense, I have a degree of confidence that there is the potential for technology to make a difference in that area. I want to give the panelists a chance to get some thoughts on that.
Okay, very specifically, we've already sent a delegation to Chicago to look at their program. And we're all well aware of it. We're working, when I say we, my committee specifically, is working with the Florida Bar Foundation, and the clerks already have, they're working on that type of program. So we're very much trying to be more on the cutting edge. We weren't given a lot of time to get into the weeds on what we're doing, but absolutely what you're saying is on point with what we're doing. And by the way, not just for the low income, but for the moderate income as well, because whatever system we implement to improve that access to services will assist all of those people.
You know, just one of my favorite access stories was someone pointed this out to me. If you go to any large building now, or any building of any kind, almost always by the door, there's a little round button. If you press it, the door opens automatically, right? And it was designed for people who have mobility issues or in wheelchairs and so forth. The thing of it is, everybody uses it. Right? Isn't that true? We all do that. We got coffee in one hand or whatever, and you bang it like this, and you walk through, right? We talk about accommodation. I don't like the word accommodation because it suggests that we are inconveniencing ourselves somehow to make it easier for somebody else, right? I think it works the other way. I think you make steps like this, and everybody benefits. You do it for low income, moderate income, high income. Everybody benefits from it. I have 3 questions which came in over Twitter, and I'm going to run through them really fast before introducing our president. Okay, so from @JoshRogers, I feel like a DJ. I've got your requests here. And the question is there a software package on the market that automates the majority of legal functions? And so far as I know, the good news, the answer is no. I haven't seen it, and I think we're away from that yet. A ways away from that yet. Certainly there are specific individual packages and technology things that can do items of various kinds, but there is not yet a solo in a box, so to speak. Now, is that possible? I think yes, it is, but I think it's likelier that we'll see technology that will allow you will support you in a practice. And certainly there's technology out there right now, and if you're here live in Orlando, in the vendor area, you'll find lots of companies that will allow you to run your business and run your practice in a more effective manner, and cloud-based, et cetera, et cetera. That's great. So those tools are available, but to my knowledge, the killer app is not yet here. Do you have any thoughts on regulatory developments in England and Wales, particularly non-lawyer ownership? Touched on this briefly. They are called alternative business structures, or ABSs. There are approximately, I think now, 300 such entities licensed in England and Wales. It's interesting, a great number of them are what you would call traditional law firms, taking advantage of this opportunity to do something like really simple. Like it's a sole practitioner who's been doing this for like 25, 30 years, and his wife has been running the business for the longest time, but she can't be a shareholder. She can't be an equity owner because she's not a lawyer, right? So they changed the rule, now she can be part of the operation because she truly is a partner in the business. But at the same time, there are these other providers coming in, and a lot of them are coming in very much with the interest of saying, we're going to do things very differently here. We're going to come at this from a perspective where we're not lawyers. And I'll take 1 minute, because one of my favorite objections, and favorite is a little sarcastic, to this idea of non-lawyer ownership that is raised, or having shareholders. I say, well, if you had like shareholders on a law firm, well, those shareholders would, they would just operate it for the short term, and they'd strip all the money out of it every year, and empty the piggy bank and so forth. And I said, we've already got that. That's how law firms work now, right? Most of the well-run companies I've seen actually are built for the long term, and they are sustainable. As a friend of mine in this line of work, Bruce McEwen, once said, there's one line that is present on the financial statements of every company in the world except law firms, and that's retained earnings, right? Because we don't do that. We don't tend to plow anything back into the firm. And the very last question that I think we have time for, not even that, from Law Tech Partners, which is, what 3 things should lawyers be doing today, all caps, to get ready for tomorrow? And if we had another 3 hours, we could probably all get into that. For myself, my closing thoughts on it is, number 1, know your clients, the ones you have now and the ones that you want to have. Know everything about them you possibly can. If you're not sure about something, ask them. If you phone them up and ask them about what's going on with their lives or their businesses and what they're concerned about and what the future holds, you will, I'm sure, be the first lawyer in several generations ever to have done that, and they'll tell their friends about it over dinner parties. So it's incredibly effective in knowing your clients as well as you possibly can, knowing your competition, And a lot of this is understanding not just what other firms are up to, but who are these new entities coming into the market, and do they have something to offer your clients that you don't? Do they have something to offer you? Right? Is it a competitive situation? Is it a collaborative situation? Right? Because what we view as a threat, LegalZoom is considered a threat by many lawyers, but many other lawyers work with LegalZoom, right? And they make arrangements whereby if someone buys a legal document online, LegalZoom will put them in touch with a lawyer in the area to review the document and look it over, right? And the lawyers say, that's great, because I want that relationship. I want to be able to build that relationship from scratch. And then finally, the thing is just know your own business as well as you possibly can, and treat it as a business. I often hear people say, and I understand where the sentiment comes from. They say, law's not a business, it's a profession. And I say it's both. It is both a profession and a business, and it is possible to run a business in a professional manner. Not only is it possible, I would submit it's absolutely necessary. And on that note, I want to introduce Gregory Coleman, president of the Florida Bar. You're president now, is that correct? Absolutely, yes. to take us out.
Is this on?
Yes, it is.
Yeah, so as I was walking down the hall, Gene Pettis' wife, Sheila, yelled out, Mr. President, and I turned around, and she said, I knew you'd turn around. I said, I was looking for Gene. Just one follow-up on that, Jordan, before I make some very quick closing comments. I speak around the state a lot about technology and about the effect of technology in our practice. And this room is the choir, so I know the answer to this question will be yes, but I'll be speaking to, say, 100 people, and I'll say, how many of you have Googled or searched your area of practice? And I'll get a splattering of hands, like maybe 3 or 4 hands. And I said, seriously? If you are practicing in the area of employment law and are suing people for sexual harassment, and you have not Googled the term sexual harassment, employment claims, things like that, trust me, the person that is walking into your office has, not to mention Googled you and everything about you. So if you don't know the information that they know, you're at a significant disadvantage. And the information may be wrong. It may be right, but it's irrelevant because it's information. And so one of the things that I'd ask you to do, because again, you are the choir, is to engage our members, engage your friends, get them involved in this process. We started this, and Gene, I wish he was here because I would thank him for his vision. It really started with Gwen Young before him. But it was initially a 3-year look at these 4 discrete areas. And 2 of the areas have raised a critical mass. One, of course, is access. And we have some immediate deliverables thanks to Adele's hard work and her committee's hard work to try and fix some immediate problems. And the other is technology, because we can't wait 3 years to see how technology is affecting our practice. It has affected our practice. It's going to continue to affect our practice. And so very quickly, for those of you that have not heard, we did create a committee that is going to provide immediate technological deliverables to our members at a dedicated part of our website. We split it into Apple and PC so we don't discriminate, and it's going to be a suite of recommended products where a lawyer that comes out of law school that can't get a job, has to hang up a shingle because they have $200,000 worth of debt and has to feed their family, can go there and see, this is the hardware I need, this is the general software I need, practice-specific software, ancillary devices, scheduling programs, those types of products. And we're going to roll that out quickly and put a bow around it with a lot of other practice management things like helping them brand, market, learn how to open a trust account, how not to get a bar complaint filed against you and things like that. So we're very excited about that. And as I walked in, and I'm sorry I've been jumping from place to place, unfortunately, I heard Judge Barnett say something about disruptive technology. And you know, the disruptive aspect of technology is affecting all of us. Instant communication with instant reaction attached to an instant or immediate emotion is a problem. And I've called that e-etiquette. And we are working on that, and we're really trying to work on the professionalism aspect of e-etiquette. So those are some of the things that we've been doing. Jerry Riskin, who is Jordan's partner and a wonderful man, when he started this a year ago, he said to us, we are doing something that no one else in the world is doing, much less our country. And we can set a tone for the rest of this country and for the rest of the world in terms of the work that we're doing. The interesting thing was when we started with 4 discrete areas. We started with technology, access, law schools, and admissions. And very quickly, we figured out that they're not in 4 silos. They're in 1 silo, and they're all connected. And so we're really working hard on cohesively putting those things together. So there are a few people I want to recognize and thank today before I make just a couple more remarks. Of course, Jordan Furlong, thank you so much for being here. He is an expert in this area. We really lean on him to provide us guidance and advice, as well as his partner, Jerry Riskin. So thank you for your keynote presentation and moderating the event. It was greatly appreciated. Would also like to thank Judge Barnett, David Hazuri, Chidi O'Kenny, and thank you for all of your input today. It was very valuable, and you all are a great resource, and thank you for being here with us. The ones that put the rubber to the road are sitting to my right. Lance Scriven, John Stewart, Adele Stone, and Deborah Curtis. It is a huge amount of work they are undertaking in trying to herd all of these proverbial cats. So thank you all so much for all of your hard work. Jay Cohen, of course, is our fearless leader at the end down there. He tries to keep the train on track and does a great job of it, as well as the bar staff. Mike Garcia, who is a friend and a research machine, as well as I see John Berry and Terry Hill in the back and some of the other Florida bar staff that really do a lot of work behind the scenes. Thank you so much. I appreciate it. So again, 2 things, if I can just pass along, and I'd be remiss if I didn't thank you for coming here and sharing your time and listening to this presentation. And those of you out there in virtual world, thank you for being here as well, remotely. 2 things. 1, I can't stress engaging your friends in this conversation. You know, fellow lawyers, associates, partners. I think it's critical for us to begin to have this conversation, not just about immediate problems, but as we look to the future. And Jerry Riskin said something that has stuck with me, and I've said it, and I know some of you have heard me say it before. Part of the problem we as lawyers have is we're trained to look backwards. And that's the way we're DNA wired. We look backwards at precedent, we look backwards at a set of facts, at the Constitution, at cases, and we have a tendency when we need to do something, if it were an analogy with a rifle, would be ready, aim, 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 and eventually we may fire, we may not, but we want the perfect shot. The business folks that are really successful and the technology folks that are really successful go ready, fire, aim. They get the bullet moving, and then they adjust in flight. And if that bullet's not working, they go ready, fire again. And I think really all of us together as a group, including all of you, need to figure out a way to look at these issues, engage in the conversation, and then fire the bullet. Because if we sit around and aim for the next 2 years, 3 years, 5 years, we're going to be in big trouble. So I applaud all of you for being here today. I thank you for being here today. I thank the panel, and I thank you all for your time. Have a great